Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. I will not go through the litany. You know that this court is known for reviewing your papers, your briefs, and the record, so please ask only for the time you actually need, not the time that you want, understanding that the time clock is for you, not for the court. If we have more questions, we can keep going, okay? People versus Jeffrey Harris. 6 and 1 and 5. M. Children versus Holy Resurrection Greek Orthodox Church. Respondent? Respondent? 4 and 1 and 4. Ask for what you need, not for what you want. Our children is submitted. Michael Davis versus Columbia University. 4 and 2 and 3. Thank you, gentlemen. PCT Contracting Inc. versus Riggs. Do you have a cross appeal? Yes, that's correct. Okay. All right, so let's do 5 and 2, 5 and 2. People versus Diaz is submitted. Fiedler Companies versus New York Marine and General Insurance Company.
Appellate 3 and 1. Respondent 3 minutes.
3 and 1 and 3. Thank you, ladies. Matter of Elizabeth DeSanchez versus JP Morgan Chase. 4 and 1 and 4. Tower National Insurance Company versus Joseph Lugo.
Appellant, defendant, 8 and 4, please.
Respondent?
Respondent, cross appellant, 5 and 1.
5 and 1, 5 and 1. People versus Jaqueen Sanis.
Yes, appellant requests 5 and 1, please. Respondent
5 and 1 and 5. Lanza versus Kaiser. Okay, it seems you're here alone. Would you like to submit? Thank you so much. People versus Espada. 4 and 1 and 4. Chen versus 111 Mott.
Plaintiff responding requests 4 minutes.
Okay. 5 and 1, 4 and 4. A matter of Jen Wellner. That's a submit. DeLeo versus JP Morgan. DeLeon, sorry, DeLeo. I had it right the first time. 5 and 2 and 5. Okay. Arkin versus Howard Kaplan.
Your Honor, we have two sets of appeals, and I'm not sure how the court was going to do that. I would request, I guess, 7 minutes and then 5.
We're arguing it all together, so give me your total amount of time.
7 and 5, Your Honor, 5 in part to respond to the other side. For responding so loud and only,
Okay. 5 and 1, and I'm going to give you 2. Okay.
Your Honor, there was hearing for the respondents on the second appeal, and I request 5 and 1.
You are here for whom?
Arkin and Arkin Kaplan.
And you are here for whom?
I'm here for Kaplan, myself, Michelle Rice, and Kaplan Rice, and so I'm responding to 2 people, so I would just ask for
You got 5 and 1. And you?
I'm just here for respondents so loud.
Okay. So 5 and 1 and 4 and 2. Okay? Esteban Jill Soriano versus Northwind is a submit. Gilliam is a submit. Okay, first case on the calendar, People versus Jeffrey Harris. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Shaili Dewanji Sharma from Covington and Burling, pro bono counsel with the Office of the Appellate Defender for Mr. Jeffrey Harris. Mr. Harris was convicted of 1 count of attempted murder in the 2nd degree based on a surveillance video in which we cannot see the shooter's face, an unrecorded statement in which Mr. Harris disclaimed knowledge of the shooting, and a Riker's phone call in which Mr. Harris denied being the shooter. The people did not present the victim nor any of the many eyewitnesses to the shooting at trial to identify Mr. Harris as the shooter. They also offered no weapon or forensic evidence linking Mr. Harris to the shooting.
Your client's statement was not just a denial, isn't that right? He also kind of inadvertently made a statement that was incriminating. Isn't that right?
Well, I disagree, Your Honor. He does say you
He
cannot...
says, that wasn't me. The video didn't catch my face. How would he know that the video doesn't catch the perp's face unless it was him in the video?
Well, Your Honor, the specific language he says is, my head is turned away, but Detective Nash...
Again, how would he know that? I'm assuming that at the time that he made this statement, he had not had the benefit of the discovery that you received or your counsel below received with regard to this video, so he would have no way of knowing unless he was there.
Well, Your Honor, he's actually, the testimony that Detective Nash gave was that he's looking at Exhibit 4A, which is a still image in which there is no face visible at all. And so the fact that he's looking at that statement when he's saying you can't see my face suggests that, it's not really as inculpatory as the state makes it.
Well, if someone hadn't been there, I would have said, you don't see a face, not you don't see my face.
Well, Your Honor, he does admit to being in the lobby before the shooting. He just denies being the shooter.
Okay.
So,
were there other people on the video wearing similar clothing, similar hat, etc.? In that video?
Well, there's no one on the video that you see wearing that kind of clothing, but, Your Honor, it is the lobby of a very busy building. You see people coming in and out multiple times, and this is in the stairwell. So somebody very well could have come down the stairwell.
Wearing exactly the same thing?
Well, Your Honor, it's a black sweatshirt and jeans.
And jeans that were torn in a particular place, right? They weren't just,
Well, Your Honor, it's got some kind of bleaching pattern on it, but there's no clear indication of it being distinctive in any way. And in any case, the fact that we don't see the shooter's face suggests that the jury actually had to make an inference that this is the same person who we see in the lobby moments before.
Counsel, I watched the video and I saw when the shooting happened, the brim of a baseball cap that was similar to the baseball cap that he's seen to be wearing earlier in the video. Why can't the jury use that as an inference?
Well, Your Honor, it's not that the jury can't use it as an inference. The point we're trying to make is that the jury had to make an inference, and so the trial judge should have given a circumstantial evidence charge, as was requested. Again, there's no eyewitness to the shooting who's saying, this is Mr. Jeffrey Harris who is the shooter. The jury had to make that inference. Each of the pieces of evidence that the people offered was wholly circumstantial. And, I'd just like to briefly go through each of those pieces of evidence. The surveillance video that we talked about, it doesn't actually conclusively identify Mr. Harris as the shooter. And all we see is that he was in the lobby at some point before the shooting. The custodial statement that he makes that we also discussed briefly, again, he admits being there, but he explicitly denies being the shooter. And so the jury had to draw an inference that the rest of the statement, when viewed in context, was inaccurate in that he's actually saying, when he says, "You cannot see my face," he's admitting to being the shooter. And the third one that the people presented was the Riker's phone call. And in that, Mr. Harris once again denies being the shooter. He admits only that he was in the building at the time of the shooting. And so the jury needs to infer that by admitting that he was in the building, that amounted to him being the shooter. And these three pieces of evidence do not make an incontestable admission of guilt, and so they cannot be circumstantial evidence. And I'd like to just note, the circumstantial evidence charge says it must appear that the inference of guilt is the only one that can be fairly and reasonably drawn from the facts. And the evidence excludes beyond a reasonable doubt every reasonable hypothesis of innocence. And that's certainly not what the evidence amounts to here. And that's why the trial judge should have given the circumstantial evidence charge.
So, counsel, did he raise that issue below? Did the trial counsel make that argument?
He did raise that issue below. He requested the circumstantial evidence charge, and it is preserved.
And why isn't the video direct evidence?
Because you don't actually see the shooter's face in the video.
I mean, but so what if the face is grainy? It doesn't, that's what I'm saying to you. The simple fact that you can't see the face, you see a person dressed like the defendant, you see him stick his arm out, and you're saying just because you can't exactly see the face, that makes it circumstantial as opposed to direct?
Yes, Your Honor. In fact,
you're saying if this face was grainy in the video, that would also make it circumstantial rather than direct?
Well, if you cannot clearly identify who the individual is,
I looked at the video. I think I could clearly identify who he is, despite the fact that the face is not completely clear. And I don't think there are any cases that say that the fact that the face isn't completely clear makes it circumstantial evidence as opposed to direct evidence.
Well, Your Honor,
have you found any?
Your Honor, I'd just like to make 2 points. One is that you actually can't see the shooter's face at all. All you see is an arm.
You see the person. You see the person. You see how he's dressed, right? It's just the face, but you see the person. And that person has the same clothing as the defendant who walked into the building and into that stairwell a couple of minutes before the shooting. You're saying that that's circumstantial simply because you can't see the face, even though you can see the person who's dressed exactly the same. That's the problem I have. I think that is direct rather than circumstantial evidence, right?
Well, Your Honor, there's a case out of the 3rd Department from earlier this year, People v. Taylor, in which, the facts of the case are somewhat similar. The individual was identified using a black sweatshirt, and the 3rd Department held that that was circumstantial evidence because the jury had to infer that the person wearing the black sweatshirt that they see in an earlier video is the same person wearing the black sweatshirt committing the crime.
Okay, thank you. You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Emily Aldridge, the People. Defendant's claimed, to begin with, is unpreserved. Never once did he advance the specific arguments that he is making here, that there was no direct evidence and that the video showed only a disembodied arm.
Is the video the only direct evidence?
Well, there's the video, there's the phone call, like as Judge Manzanet Daniels was talking about, how he's using the first person, my, and then there's also the Riker's call. Now, counsel has said in reply brief.
The middle statement, you mean not the phone call, but the statement made to the investigator, which he then recited to the DA? That's what you're talking about, where he uses my?
Yes.
Okay.
My head, yeah, that's not me.
Can we be sure of the reliability of that statement? It wasn't recorded, it wasn't written down contemporaneously by the detective, right? He recited it to a DA over the phone, correct? Is that what happened?
I don't know that it was over the phone, or I believe he said he went to the complaint room. I believe that was the testimony, is that he went to the complaint room. But even that alone is not the only thing. There's two different statements. There's the statement to Detective Nash. There is the statement in the Riker's call, and there's the video. There's three separate things. And just to clarify, regarding talk of a couple minutes later it came out. It's not a couple minutes later that he came out. 17 seconds. 17 seconds after he walked into the stairwell. And first of all, the video shows him, yes, he's hanging out. He's kind of bopping around with presumably his friends. He steps out a couple times. It's November, but you see people are not particularly bundled up. He steps outside several times. He's not bundled up. He goes for a short walk. We don't know where he goes. He comes back shortly thereafter. All of a sudden, he's got his hood up. He makes a beeline for the stairwell. No interaction whatsoever with the people he'd just been hanging out with. Beeline for the stairwell, hood up. Counsel admitted that was him. And again, 17 seconds later, the hand comes out. You see the hand, you see the bill of the hat, you see the front of the jeans, you see the reflective object on the shoe. There's an argument in the reply brief that, oh, well, maybe there was an issue with the camera, so maybe it wasn't 17 seconds, maybe it was a couple minutes. The fact that you can see more than just the stairwell, you see the people hanging out. You can see there's no jumps, there's no issues there. And just to address the authentication just very, very briefly, their claims rest on a blatant mischaracterization of the record. There was no command to order the maintenance records. The trial court said that although it would have laid a better foundation, it was adequate the way it was. And that was that the inspection was done 3 days after the shooting occurred. And if there are no further questions, I rest on my brief. Thank you.
Thank you.
Your Honor, I'd just like to start with the preservation point for just 1 second. Contrary to the people's assertion, the issue was properly preserved for appeal. Trial counsel made a timely request for the circumstantial evidence charge, and the trial judge denied that request and provided his explanation for why he is denying the request. The law does not require trial counsel to repeatedly object to preserve his argument for appeal.
Under the preservation rules that we have to operate on, the trial attorney has to articulate the specific objections and the same arguments. And I think that's what the issue is here about preservation. Of course, you can always ask us to review something on the merits nonetheless.
Yes, Your Honor. Nevertheless, we do believe the issue was preserved because he does raise that a circumstantial evidence charge was warranted.
No, but he
And the
doesn't
trial judge-
articulate his arguments with respect to why it's warranted. That's the rule in this state.
Your Honor, the record as it's laid out actually shows that counsel had a conversation with the judge. It happened to be off the record, so he re-raised it on the record, and the trial judge responds and provides his specific reasons for why he is denying the circumstantial evidence charge.
Thank you. We're out of time. Thank you so much. M. Children versus Holy Resurrection. You may proceed.
Good afternoon, Your Honors. Mr. Mermelstein. My name is Matthew Calvin, representing the appellant here, Father Cahagias. This incident, as this Court's aware, occurred back in May 10th, 2015 at the Holy Resurrection Church. There have previously been co-defendants in this case, being the church itself, the Archdiocese, as well as my client, who had been referred to by this Court in the prior decision as a substitute priest. The issue now here is whether, in fact, this case should be going forward or whether it should be dismissed. As where Father Cahagias had already filed personal bankruptcy, and what was left was a carve-out in the bankruptcy that the plaintiffs could go forward to seek to try to recover through him to the insurance company. That insurance, there are two carriers.
Counsel, can't they, that implies that they're allowed to seek a liability finding against Father Cahagias, correct?
That is correct, for the purpose, though, of trying to establish to get coverage. But what you're talking about here is this Court has already found that Father Cahagias was acting outside the scope of employment. So whether he's an employee or an independent contractor, that question has already been skipped over by the finding whatever he did was outside the scope of the employment.
Well, that hasn't been judicially determined yet, right, in terms of the two policies in question?
As to the policies, no, but as to him, yes. And as this Court is aware, that this is a factual summary judgment determination. This is not a determination made during simply a course of a trial, like an evidentiary ruling. We have here essentially a homophone in the phrase law of the case. This is not law of the case of that inter-trial ruling. This is a law of the case based on a summary judgment. As a matter of fact and law, as this Court said in its prior ruling, he acted for personal reasons outside of the scope of
Father Cahagias didn't bring a declaratory judgment action, did he, against the two insurance companies?
But that's a pointless task to go, because that issue's already been resolved. Because now there's been, in the past, it's always ruled that you can't create insurance when none existed. If he acted outside of the scope of his employment, he acted outside of the scope of employment, there's no coverage. And even if the policy named him personally.
Has there been a formal judicial determination regarding the propriety of the disclaimer of coverage?
That's also a non-issue because you're, I'm sorry.
Your client?
That's also a non-issue because if there's no insurance, you can't create it whether there's coverage or not.
Well, that's the issue, though.
No, but there is no coverage because.
Counsel, we get to decide that. So why don't you answer the question?
You already decided that because you decided that he acted outside of the scope of his employment. By acting outside of the scope of his employment, that is not something that would be covered by the employer. If I may suggest, there was a case on this point specifically from a third department in a workers' compensation case of Baham, B-A-U-G-H-M-A-N versus Merchants Mutual, 213 AD 2nd, 1030. In it, it goes through that there was a workers' comp hearing. It was determined that the claimant, that the defendant was acting outside the scope of the employment. On then the review for the DJ action, it was determined that it's already been, that outside the scope of employment says no more case. That's it. There's no coverage. You can't create coverage if the person's acting outside of the scope of the employment. It's the same thing also going on.
No, but counsel, has any has any court decided whether or not that insurance policy covers this loss, regardless of who calls it what?
Well, if you want to go
I'm
to
just
what the
asking you whether there has been a judicial determination about coverage.
directly, no, there's been no.
And nothing about
of-
waiver, or nothing about late notice of claim, or any of those other things that could stop an insurance company from denying coverage, right? None of that has been adjudicated.
My question then is,
No,
though,
no, I just.
No, you
wanna-
don't get to ask
uh,
questions.
the answer
That's
is,
just-
no,
I'm-
there has been no answer
There hasn't been,
on
okay,
that,
got it.
Okay,
raised in that matter.
you'll have time on rebuttal, sir.
Thank you, Your Honors.
You may proceed.
Thank you. May it please the court, Stuart Mermelstein for the plaintiff respondents. The issue begins and ends with the fact that there has been no insurance coverage determination in this case. Father Kahagi has never brought a DEC action. It's an open issue as to whether there's insurance coverage. There are arguments in favor of insurance coverage that we indicate in our brief that have not been addressed. And that's an issue in accordance with New York law to be determined post-judgment.
There's been a finding, however, that Father Cahagius was acting outside the scope of, or that his son was acting outside the scope of any type of employment. The priest and the son were acting outside. So there has been a determination as to that, correct?
There has been a determination, yes, in the appellate division, affirming that he was acting outside the course of scope of his employment. But that does not determine insurance coverage. And if you look at the policies in this case, the potential coverage is broader than simply scope of employment. So it's an open issue. This is not an insurance coverage action that is before the court. It's an underlying tort action.
I mean, they have disclaimed, but that has not been litigated to the end.
Right. The plaintiff has not had an opportunity to litigate that, which under the law, plaintiff would have an opportunity to litigate post-judgment. And then they may bring a direct action against the insurer and challenge the disclaimer, challenge the denial of insurance coverage, and bring the issue to the fore. And at that point, the insurers are in place to make their arguments. Father Cahagius shouldn't be making the arguments for non-coverage, which turns the expected positions of the parties in this case topsy-turvy. That's not the way it should be. The plaintiffs have the right to seek a liability finding, get a judgment based on liability. While they can't go after Father Cahagius personally, they can pursue a direct action against the insurer. The insurers can then come in and assert their defenses, and then the issue can be litigated between the appropriate parties.
What his application is premature according to your position, correct?
Yes, absolutely. Again, it's insurance coverage is not an issue in this case. And I think that covers my argument if there are no further questions.
Okay, thank you.
Thank you.
Counsel, you have a minute.
Thank you, Your Honor. Your Honor, I do agree that this is a unique situation, but the unique situation winds up as a result of the bankruptcy and the findings involving the co-defendants. That, as the court said, as a matter of law, that my client was not acting in the furtherance of the church's business and the archdiocese's business within the scope of his employment.
We understand that, but that's not the only question. The question then, after that determination is made, is what are the terms of the policy? And whether this act and his actions fall within it or not, and that has not been determined.
But as the courts have found in Cantrell case and the like, the claims here in paragraphs 31 and 33 is in fact the sexual abuse and in fact the sodomy, both of which as a matter of public policy have to be excluded. They're not covered. So now you're left with conduct.
And
would not
so
be
once
tolerated.
the insurance policy is before a court can determine that. Thank you.
Thank you, Your Honor.
Davis versus Columbia University.
May it please the court, my name is Scott Singer. I represent the plaintiff appellant in this action. This court sees lots of cases.
Mr. Singh, I'm a little confused here. I know what a 2x4 is, and I know what plywood is. And as I understand it, your client tripped on a piece of 2x4, is that correct? Or that's the allegation, anyway? That's the allegation,
Yes, it's uncontested.
that he tripped on a 2x4.
Yeah.
Now, were there any ongoing jobs on the site that were using 2x4s?
Well, when you mean on the site, I can't speak for other floors.
In that area?
There was nothing, nobody was using 2x4s then, because the process is, first they frame it out with the 2x4s, they put up the forms, then the lathers come, they put in the rebar.
So they were using 2x4s?
The lathers were not using 2x4s. Only carpenters were using 2x4s.
Uh-huh.
And the carpenters weren't in the area. It's uncontested that they weren't in the area at the time.
When were the 2x4s used by the carpenters?
So the 2x4s were used by the carpenters, that was the form work, when they put up the forms at the very beginning.
To pour the concrete, to get ready to pour the concrete?
Well, first they put up the forms, then the rebar has to come in.
Right.
Then the lathers put up the rebar, then they pour the concrete, and then 28 days later they take down the forms. So that's, then the carpenters would come back. But at the time of the accident, it's uncontested that there were no carpenters there. And in fact, the plaintiff said that there were no carpenters there. There was his coworker put it in an affidavit.
But the question is, at the time of his fall, was he traversing a space that had forms still in place waiting for the curing to complete? Or was the 2x4 piece of wood that he tripped on a piece of discarded form?
It was discarded. There hadn't been a concrete pour. Part of it had rebar and part of it didn't have rebar, but the pour hadn't taken place yet.
So they were still in the process of doing that?
Well,
that work had not yet been completed then?
Well, yes, it wasn't a complete area, but, you can't leave pieces of 2x4s around for a month while,
Do we know it was for a month? I mean, obviously, the question we're getting at is, was it integral to the work being performed at the site on the 13th floor at that time?
It was not integral.
How do we know that it was there for a month?
No, I'm saying that it takes 28 days to cure the concrete.
Right.
So after the concrete pour, which hadn't taken place yet, it'll be another 28 days before they could take away the...
maybe they were getting ready for the pour? I mean, and so they wanted some 2x4s there to help make frames? I don't know.
They wouldn't need 2x4s. The formwork, by the way, the testimony by the defendant's witness, Alex Solnick, he said, had work been commenced in the ground floor? Yes, it had. Had the formwork been constructed? Yes. There was no formwork being created at that time. It was all done. It was all done, and it was ready to, for the rebar work and then the concrete pour.
Let me see if I understand this correctly. The 2x4s are used in the creation of the form prior to the pouring of the concrete, correct?
Yes, yes.
And the carpenters had not been on the premises in that particular area using the 2x4s for a period of time.
That's correct.
And what does the record reflect as to that period of time? What is the length of the period of time?
I don't think it's specified, but clearly part of the area had rebar installed. So it was a period of time. It was days or weeks. The rebar was laid on part of the floor, but not on the entire floor. So it was a significant period of time had elapsed since then. And I think even a day.
Counsel, did anyone testify to that? Did anyone testify to the period of time?
Testimony was that,
The testimony is that the work was all ongoing, including using those forms. The question is, you're saying there was a significant period of time. Is there testimony there to that?
there wasn't any quantitative testimony, but the testimony was that the form work was completed at that time. There was no ongoing form work, and there were no carpenters working there at the time.
Okay, you'll have 2 minutes on.
Thank you very much, Your Honor.
Good afternoon, Your Honors. May it please the court. My name is Howard Altman. I represented the defendants. I have to say, you did my job wonderfully for me. You
Don't jump up on any horse. I wouldn't if I were you.
Okay.
So why don't you tell us, is counsel correct that at the time of the accident, that portion of the work in creating the forms for the pouring of the concrete, had that portion of the work been complete already?
That was not testified to by anybody. And importantly, the carpenters counsel refers to was plaintiff's own workers, DeFama Concrete. There was no separate carpentry company. The farmers' workers would come in, lay the wood. Then the farmers' workers number 2 would come in and put down, tie the rebar. Then the farmers' workers number 3 would lay what's called the chairs.
Okay, but my question is very specific.
I understand.
Because it seems to me, if I understood the record correctly, what was supposed to happen was that workers were supposed to create a form out of the 2x4.
Correct.
Then they were supposed to lay the rebar in preparation for the pouring of the cement.
Correct.
Correct? So am I correct in assuming that once part 1 is done, the creation of the forms, once that portion of the work is complete, that any extra 2x4s that had been cut, were not being used as a part of the actual form, would be discarded and cleaned away?
That was not in the record because while they were creating the forms in the way...
Is that what was supposed to happen?
Ideally,
Isn't that
yes.
what the record said?
What the record says, that was the process, but it was what the record didn't say is whether, and pretend, for example, this is the first floor he's working on, whether you created a form here and it created a form over here, or whether you created a form, put in metal, then lifted this part bare. The order in which, whether it was completely shore the floor, or shore part 1 of the floor, do rebar, shore part 2 of the floor, that part was not in the record. There was not specific testimony.
But what was in the record was that debris was not supposed to be permitted to remain in a work area.
That is true.
So again, if the form has been completed, were the workers supposed to clean out the work area of all unused 2x4 material?
That's the way it was supposed to be, but as the trial court correctly found, and as Your Honors correctly noted in your questions, it was unclear whether this 2x4 was debris or was something to be used or being used in shoring on this part of the floor.
Okay.
And unless Your Honors have any questions, I can save
Let's
your
talk
time.
about the Labor Law 200 and straight negligence, common law
Yeah, Labor
negligence.
Law 200, the trial court...
Did you all carry your burden to show absence of constructive notice?
Oh, we didn't need to show constructive notice because this arose out of the manner of the work. There is the Maddox case by this court, 2016, where the court said any debris, work materials, or the like arising out of the manner of the work, that goes to work methods, and only a general contractor that controlled the means and methods of the work can
Why couldn't it also be a dangerous workplace case, in which case you would have to have actual constructive notice?
Not under the case law in this department. The conditions inherent to the land are things like broken steps or actual permanent fixtures, and not debris and work materials that ebb and flow of the nature of the work.
So you're saying that a construction, a GC is permitted to allow debris to litter a work area, and so long as work is ongoing, that's okay, and if workers get hurt, oh, too bad?
Of course not. Then the construction worker, general contractor, would be liable under the relevant section of 241 sub 6.
Why not under 200 in creating a dangerous work environment, as my colleague just asked?
Because the case law in this department from Maddox and its progeny hold that when it alleges from the work methods, only a general contractor who directs the means and methods of the work can be liable for such.
So if we disagree with you on that characterization, what other argument do you have?
Other than the binding case law of this, that it was an ongoing construction site that even plaintiff didn't have notice. Plaintiff himself said, this 2x4 was hidden behind the wall. There was no way to see it.
Counsel, wasn't the point, though, that the trial court made was that there was a height differential, like 18
Yes, because the
inches,
floor was being
and that's why
constructed.
and that was something that you could have caused and created, and therefore, it wasn't just about the piece of plywood, it was about the height differential between
Right,
how
and,
he fell.
and this court
That
addressed
could have
that.
clearly been a cause and create under 200.
Right, and this court addressed it in Franciscoan versus Gucci America, 105 AD 3rd 503, where there was a step down of 12 to 15 inches between one portion of a work area and the other. And the
But in
court
this
said
case,
that's
it's
part of the
2 to
work.
3 feet, right?
It was, but it still
So
remains
that's a lot, 2 to 3 feet is a lot different than
It is.
18 inches. So
But
we
what the
could-
evidence, the record,
we
and I
could-
apologize, I'm out of time, but I'll answer your question. What the
It would
record
help if you allowed the judges to actually ask their question before you start talking on top of them.
I apologize, Your Honor.
Okay, thank you. Counsel, I'll hear you.
Thank you, Your Honors. I just want to deal with the 200 aspect. First of all, I cited in the brief, there were two cases, Singh and Spencer. Both of them said that the presence of debris was a dangerous condition at the work site, which could give rise to the Labor Law Section 200 liability. The second, it's a case I cited in the brief, but I didn't discuss, and I think it's worth looking at, Sleekus against Cyclone Realty. It's a second department case. It is cited in my initial brief, 78 83rd 144. That case, a painter left a crowbar in a doorway, and a woman that was working there tripped over the crowbar. The court said that was a 200 case. It was a viable 200 case, and added, the plaintiff's accident occurred at a time of day when the painters had already ceased their work and were no longer using their tools, including the crowbar at issue. It should have been cleaned up. The 2x4 should have been cleaned up. There was no reason for it. It's undisputed that there was no formwork being constructed at the time. And as you pointed out, Justice Manzanet, the accident reports clearly show that it was supposed to have been cleaned. It wasn't cleaned. We believe there's violations of both 241-6 and 200. The court clearly erred in dismissing the 200 claim on the basis of the controlling case law. If there's no other questions, you have my brief. I addressed the 23-1.7F claim, and your honors are all aware of the Ferguson case, which was a similar height differential and found to be a violation of 23-1.7F.
Thank you.
Thank you very much, Your Honor.
PCT Contracting versus Riggs Distiller and Company. You may proceed.
Thank you, Your Honor. May it please the court, I am John Hay from Denton's, attorneys for the defendant Riggs, Distiller and Company. In this case, PC contractors brought an action alleging that Riggs breached an asset purchase agreement by not paying a broker, Robert Baker, and his company HMC Consulting, a brokerage fee of approximately $1.3 million.
Counsel, doesn't this come down to whether or not the PCT's failure to disclose the existence of that letter agreement fit within the requirements of the material contract section of the asset purchase agreement?
That's correct, Your Honor.
And so I've been looking at that asset agreement. I've read both of your arguments. How do we know, and Judge Ostrager said, look, there's a lot of issues of fact. Both sides claim different things. I can't make a decision based on the record. What do you think that he missed that would show that you absolutely are entitled to summary judgment on this record as it exists at this time?
Okay, you're correct, Your Honor, in that the only real issue here raised in defense of our motion for summary judgment is a legal interpretation of what is meant by material contract. And that's why we're entitled to summary judgment, because in our view, material contract clearly include this $1.3 million broker fee. And it,
Because this was an agreement about the sale of a business. It wasn't like a real estate transaction. That wasn't what the APA was about. And that's part of their argument, right? That this was really not material in the context of the, the big business was being sold.
well, you have to go through the definition of material contract. And we start off by their assertion, material contract is defined in Article or Section 4.07A.
Right.
And it basically says that, and I'll not quote it, but paraphrase it quickly. It says that material contracts are contracts to which PTCT is a party or is bound in connection with the business or the purchase.
And that's the big thing. They're arguing in connection with the business excludes it, at least arguably.
Sorry, I didn't mean to interrupt, Your Honor. Yes, and in fact, the asset purchase agreement defines business as the entire business, not just what has been sold, but the entire business of PCT, and that is done in the recitals 1 and 2 of the asset purchase agreement.
So counsel, isn't this contract though, doesn't it have to do with the sale and not the business itself? I mean, isn't that a reasonable way to interpret that? The business is, the oil business or the rig business, or let me see what kind, it's the gas business. And so that's what I'm saying. The business is the gas business. It's not a broker fee to someone who I hire to help me find a financing or a purchaser, an asset purchaser. Or let me just say, I'm not saying that your interpretation isn't one good one, but it's not the only one that one could take. I would not normally assume that if you're talking about a gas pipe business, that a broker's contract is part of that business, right? That's not a natural assumption to make.
Well, it's of the business, but it's of the business which includes the assets, and this relates to the sale of the assets. It's
so if
in
you
connection.
have purchased assets, how does a brokerage contract have anything to do with the purchased assets? The assets are the gas main installation contracts, right? That's the assets that are being sold.
Well, it's in connection with those assets, and what's happening is they're selling those assets.
Right.
So that's why it's in connection with the business, which is those assets that you're selling.
I think what I'm trying to say is it's not so clear to me that this is part of that interpretation, that definition of contract.
Counsel, was the reason that the provision in the contract was added regarding what the obligation of the buyer would be concerning any broker's commissions was included in the contract? Why? Was that part of the negotiation over the whole deal?
Yeah, it was part of the negotiation of the price. That's, when, for example, and to the point that it's not part of the business, the parties thought it was part of the business because they included the Madison 1 brokerage agreement as a contract that was a material contract to the business as part of the disclosure. They disclosed that brokerage agreement. They just didn't disclose
this one.
This one.
Is there a list of material contracts you're saying?
Yes.
And that there is a list that says here's the material contracts that we mean, and this one wasn't in it?
Yes, Your Honor. It's Schedule 4.07 of the contract has a list of material contracts, one of which is one broker agreement, which was the Madison 1 agreement, but conspicuously absent from that list is the Baker agreement.
Okay.
Thank you. You'll have time on rebuttal.
Thank you.
May it please the court. My name is Andrew Richards. I'm counsel for plaintiff PCT, a respondent and appellant.
How can a letter agreement that quadruples the amount of commission that that they have to pay, how is that not material to this deal?
As you discussed with opposing counsel 5 minutes ago, it's not material under the terms of the APA itself.
Well, doesn't the APA, we've been talking about section 4.07, which is entitled Material Contracts. And there's, as counsel pointed out on page 44 of the record, there's a list of what would be material contracts. And Roman numeral 5 says all broker, et cetera, contracts. So how does this get excluded if it's included there? Isn't?
Okay, it's an unsigned contract. I'm sure you're aware of that from the papers.
Yes, but I mean the
I understand.
I'm sorry. The arbitration that you had already, the arbitrator has already found that the contract was enforceable, even though it wasn't signed by PCT.
Yes, based on the conduct of the parties. What's very important here is the mindset of PCT, Baker himself, HMC Baker, I may use those interchangeably, I apologize, and actually Riggs themselves. This is not a situation where PCT was silent about Mr. Baker. His name is specifically set down.
Exactly. So if you put his name down because he's important and he was part of the production and of producing this deal, then why not include the 2015 letter agreement?
The answer to that.
Again, when that agreement changes their responsibility of commission payments to the tune of $1.3 million, if that's not material, then nothing is.
Well, it's not material under the terms of the business, the sale.
Well, that's what you say.
I understand. That's my, and let me further answer. Then if this court goes down the road to determine that the unsigned proposal should have been listed, then there's a question of fact for trial. Because as the PCT in the record says, we told Mr. Gaultier there's an unsigned agreement. We asked him if he wanted it, and he said, no, if it's not signed, I'll get him hockey tickets. So that would be a question of fact.
Counsel, at the time the agreement was made, had that arbitration decision come down?
No, the arbitration condition 2 years later.
If it had gone the other way, clearly this would not have been a contract material, right? If the arbitrator said, no, not enforceable, not gonna, then there would be no reason for us to be here.
In retrospect,
so at
correct.
the time of the contract, that hadn't been determined.
No, not 2 years. But
Are you arguing that it's not material because it was not signed?
No, it's not material because it does not affect the purchase assets or the business. Let's assume for a second.
But look, come on. If I have to decide how much I'm going to pay for something, right? And I think I'm only going to have to pay 1% on that number versus 5%.
Mm-hmm.
You don't think that extra 4% might have some sway on what number I ultimately pick on the ultimate purchase price?
If I was in the shoes of Riggs Distler, when we disclosed Bob Baker as a broker, they have to negotiate and pay the broker's fees, I would have picked up the phone and called him. This is not a situation where he was
Did that answer my question?
Yes, it does, Your Honor.
Oh, I don't think so, but go ahead.
Repeat your question. Maybe
Go ahead,
I didn't
no,
understand
go right ahead.
Okay, so again, we have a situation where the fact that it was an enforceable unsigned contract was 2 years after the fact. And again, I don't want to repeat myself because what we say is material contract, we believe is not what this contract would be. If there was a broker's contract that procured work for PCT, let's say from Con Edison, that would affect the purchase assets. That would be in conjunction with the business. But the sale of the business in itself is not what that means. It just doesn't.
Okay. You have 2 minutes.
Yes, thank you, Your Honor. Just a couple of points. Again, just to emphasize, as Your Honor correctly pointed out, it obviously is a material, it affected the purchase price. The purchase price would have been different, and that, as part of our fraud claim that we're really not at issue here, is why we believe it wasn't disclosed, because they knew that if it was disclosed, there were adjustments on purchase price based on liabilities that were disclosed, but this one wasn't disclosed. And
Counsel earlier argued that it was offered to your client, and your client said, it's not signed, I don't care. Is that accurate?
What is accurate, Your Honor, is that there was a statement by them, I'm just going by what's the record, that it was offered to the client. Our client didn't respond to that one way or another. He was told at the time, and in this context, it was, if you want, trying to get a sense for how much we have to pay Mr. Baker, the comments back and forth between our client and their client was, we'll give him hockey tickets. And they both joked and said, yeah, that's fine. And that's what the record shows. So this is the whole point of having an asset purchase agreement. You don't.
No, but what I want to know is, your client was told that there was some letter agreement, signed or not signed?
No,
and he didn't ask for it?
no, he wasn't told that there was a letter agreement, because they, to this day, deny that there was an agreement. He was told, as a matter of fact, they explicitly said, we don't have an agreement with this company. You just need to negotiate with them. We have a proposal from this company, which you're welcome to see, to which our client said, I'll negotiate with him after, because that's my obligation, is to negotiate something. From our view, given the representations in the contract, we expected it to be under $50,000 because that's the materiality threshold.
Counsel, did your client know that there was a possibility of an arbitration with Mr. Baker, between PCT and Baker?
We didn't know that there was going to be an arbitration. At one point, when the arbitration commenced, we were brought into the arbitration.
Right.
But then we were quickly dropped from the arbitration because we weren't either aware of the contract nor a signatory of the contract. So Mr. Baker dropped us voluntarily from the case.
Okay.
Thank you, Your Honor.
Thank you. Oh, he has 2 more minutes. He has 2 more minutes, sir, sorry.
I'm sorry.
No, it's okay. I forgot and my colleague just reminded me.
Okay. A
Go
couple of points. I don't want to repeat myself.
It's okay.
They've abandoned the fraud claim because they know they can't prove justifiable reliance. And it's important to note that, because they know deep down they should have called Baker. He was disclosed. So I believe this case is really a fraud claim and they cannot prove justifiable reliance. Also important is the fact that Bob Baker did not even think he had an agreement at 4% as of January 7, 2017, after the closing. His email in the record, I think it's record 552.
I guess he changed his mind when he brought the arbitration against you in July.
Well, when he got a lawyer involved, he changed his mind. Sure he did.
Anyway, but that's what Mr. Baker thinks. What's relevant is what Riggs thought, I guess, right? And what they knew about Mr. Baker, which Mr. Baker's name is in the agreement, but the proposal is not specified.
I understand that, Your Honor, and that you're right. But I'm just trying to make the point, at the time the APA was signed, this unsigned proposal in the mind of PCT and Mr. Baker, there was no agreement at 4%. There was none. And one last point, I believe one of your honors asked opposing, he's much taller than me, asked opposing counsel if they were notified of the arbitration. I don't know if it's in the record, I'm saying that right now, but I wrote a letter to them because we had to under the APA that there was a lawsuit. So they were notified of the arbitration between PCT and HMC.
Okay.
Unless there's any questions, I'd be repeating myself.
Okay, thank you.
Thank you.
The Fiedler Companies versus New York Marine and General Insurance Company. You may proceed.
Good afternoon. My name is Ann Odelson, and I represent the appellant, New York Marine. Simple, straightforward case. Fiedler Companies is looking for additional insured status under a New York Marine policy issued to Sercone with respect to an underlying labor law action where an employee of Sercone was injured. The additional insured endorsement contained in the New York Marine policy requires a written contract or agreement. It's as simple as that. It doesn't exist. Fiedler and Saccone entered into 2 proposals to do roof work at a particular project. The 2 proposals have the dates. They go back and forth with handwritten notes on the work to be performed, and it identifies the location where the work is supposed to be performed. It's undisputed, nothing in those proposals required Saccone to procure
So
insurance.
let's turn to the standalone agreement then.
Okay.
That's the January 1, 2013,
Yes.
which was re-upped every year, is that correct? Between the 2 entities?
According to the president of Fiedler, yes, there was this standalone agreement, but when asked specifically if applied to this particular project, the president of Saccone said he wasn't sure, he didn't know.
Yeah.
So that's.
Well, but didn't he also say that we would never have allowed them to work on these projects if there wasn't an agreement that required them to put them on as an additional insured, which is not an unusual situation, and they had an ongoing work relationship, it appeared, on several jobs.
They do have an ongoing work relationship, and he did say that, but again, Saccone disputed this. They literally went back and forth on these 2 proposals. You would think that 2 men did work, they would refer to the standalone agreement as being incorporated. Something to effect that both parties were on the same page that this was going to be used to for additional insured, status.
In another lawsuit, did Mr. Saccone admit that about the standalone agreement, that in fact it did?
I would submit that was a totally separate lawsuit 5 years ago. I don't know if it was the same circumstances on
Did
the
he give that
standalone
statement under
agreement.
oath?
He did give that statement under oath, but I don't know particularly the contracts that were involved in that and the standalone agreement, whether it was the same one. But by literally saying that he was not sure, at bottom, there's an issue of fact about whether our duty to defend is even triggered.
So your insurance company issues a statement including the Saccone here. What should we read into that?
I'm sorry, the certificate of insurance?
Yes.
That's not issued by New York Marine, that's issued by a broker, and it's not binding on New York Marine. New York Marine has nothing to do with that.
But you accepted the payments for that certificate?
No, New York Marine doesn't get any, that's separate and apart. The insured's broker gets that certificate, but the broker is an agent of the insured, not New York Marine. It's not binding on New York Marine. New York Marine has nothing to do with that certificate.
But we know that certificates of insurance don't prove that there's insurance coverage, but they certainly are evidence that we can consider, because I mean, if we find that the standalone agreement was in any respect ambiguous, which perhaps it was, can't we consider the extrinsic evidence like the Supreme Court did, and consider all these different aspects?
I would say you could look at the extrinsic evidence, but in different cases where the person that is seeking to be bound by the agreement is not saying, he didn't sign off on this agreement. He didn't say, yes, I was supposed to get insurance coverage for it. To me, that speaks volumes about the intent of the parties with respect to the proposals and whether this standalone agreement would govern this particular job site. Just going from the president of Saccone himself, who did not say emphatically, yes, I was required to get them additional insured coverage. Whether that certificate pertains to another contract, another job they were doing, I'm not exactly sure.
Well, counsel, doesn't Rodriguez say the opposite, that he has to refute it? And he never said, no, that's not true. Doesn't the Court of Appeals in Rodriguez say, all we need is the exact same language that we have here, the person who is seeking to assert the insurance saying, yes, it's covered, and the other person not refuting it. And Mr. Saccone didn't refute, didn't say, no, that's not true. All he says is, I don't know. That's basically saying nothing, but it's definitely not refuting coverage.
It
I'll
was-
allow you to answer, and you're over time, so make it
Understood.
concise.
Really quickly, Court of Appeals decision, both parties were on the same page. There was no dispute here. He's not saying he agreed to be bound by it. He just wasn't sure. At bottom, issue of fact for the jury. Thank you.
Thank you.
Good afternoon. May it please the court, I'm Deborah Summers for the plaintiff respondent. I want to talk a little bit more about the Rodriguez case because while it's significant in the way that you indicated, the other issue is that, like in Rodriguez, the argument that this standalone agreement doesn't apply to this project because no site is mentioned would render that agreement meaningless. And we can't construe an agreement in a way that would render it meaningless. That just violates all principles of contract interpretation. The agreement itself has a couple of clues. In addition to the fact that it doesn't specify a particular project, it's got references to work with a lowercase w as opposed to a capital W, which we often see when the work is specifically defined. There's also a line in the indemnification section that refers to a job but for which Sircone has been retained by Fiedler. So it's a job, which suggests that it applies to many jobs, not just a single job. There was testimony from my client that this agreement applies to all of their jobs. Mr. Sircone, while he was obviously very well prepared for his deposition, stopped short of denying that it applied. He did concede that it was an annual agreement. He also conceded that it appeared to be general. And as Justice Moulton mentioned, there was another case where the same agreement, the only difference was the handwritten changes that were made on this agreement. That was new, but the rest of the agreement was the same. None of those handwritten notations are germane to the argument here.
Counsel,
In that other case,
did Mr. Sircone ever testify that he could do this job without insurance?
pardon me, I'm sorry, I
Did
didn't
he
catch
ever
it.
say it would be okay to do the job without insurance?
He did not.
So, his understanding that that was a general policy, and that's what the plaintiff, Fiedler required, correct?
Right, that's how I
He
understand.
testified that they require us to have this insurance. Correct?
Exactly.
Okay.
The certificate of insurance, too, is important because it's evidence that Sircone understood that it had an obligation to procure insurance, and it actually specifies all projects, all locations. And that was issued just a week after they signed this agreement. So if the court has any questions, otherwise I'll just
Thank you.
on my papers there. Thank you.
Thank you. Very quickly, just a couple of points to emphasize. It was an ongoing work agreement that the two of them had. So he was not asked whether he ever performed work without, getting insurance, or whether this particular certificate of insurance pertained to this job or several jobs. So I think it's just kind of reading into the record things that haven't been exactly proven, and especially if Sircone, who is supposed to be, bound by this agreement, is not saying that he agreed to the terms therein. Thank you.
Thank you. Matter of Elizabeth L. DeSanchez versus J.P. Morgan. You may proceed.
Good afternoon. My name is Mark Sullivan. I'm here on behalf of the appellant, Pedro Arellano Lamar. The basic fact that permeates this whole case is that J.P. Morgan has no idea what happened to Trust 5462. It uses its own failure to keep and maintain records as a shield and offers a scenario that's based on surmises and speculations in which all the stars align so that it avoids liability.
Well, I mean, this trust, the existence of this trust seems to have disappeared around 1940. There don't seem to be any records after approximately 1940. So how are we going to ever get to any point different than we are at today? What has not been done? I mean, how are you ever going to show that there was this trust that existed? What inkling of proof do you have? I mean, even if you don't have the burden, I mean, they've shown all these things that it wasn't talked about in the extensive correspondence between the parties in the 1940s and the 1950s. What else can they do, and what else are you expecting them to do?
Sure, we know the trust existed. There's documentation of it.
We know
that
it
it was
existed
funded.
at one
We know there were
time.
assets. And we know that the trustee has the burden to maintain the records. The family has no obligation to keep records. The trustee does. The trustee is a corporate trustee who, through its predecessors, has been in effect since the initiation of this trust. The fact that after 1940, we don't know what happened, that is on their shoulders. It's indisputable that a trust existed. What happened to it? It's their burden to establish that. In order to show that the trust was revoked, they needed to come up with 3 documents. They needed to show that there was the trust instrument that showed that the trust was revocable. They needed to show a revocation.
Well, prior to 1940, Mr. Sanchez was completely involved and ever present in her own investments. She was fully engaged, not just in her trust, the trust we're speaking of, the 5462, but also the 6th trust for her children.
Fair
She
enough.
was completely engaged.
Fair enough, and I would agree with that. But the fact that there are no records doesn't indicate that the absence of records is not proof. The fact that the trustee does not have any evidence of things after 1940 does not mean they don't
I don't
exist.
think that that's accurate. There are lots of records, thousands and thousands of pages of emails back and forth, and the discussion about 5462 ceases after 1940 at about the time that she was discussing the serious tax implications to maintaining, as I understand it, from the inception of the trust till about 1940, the tax burden had increased exponentially on this account. And she was very concerned about the tax implications.
Let me answer 2 aspects of that. One, the fact that there was extensive correspondence in the Children's Trust only demonstrates—
And hers.
Well,
prior to 1940,
up to 1940.
her communications included hers as well.
Indisputably. The fact that there was extensive communications with the Children's Trust would evidence that the trustee knows how to maintain records, and it did in those cases. The fact that there's nothing in 5462 after 1940—
Why is the court's determination that based on that evidence, as you just so accurately pointed out, J.P. Morgan kept incredible records for the 6 Children's Trust. So why is it unreasonable for the judge below to have concluded that based on that fact, the only thing that can be surmised based on everything that she did have before her, that it is evident that Mr. Sanchez asked for that trust to be revoked and to hold the $60,900 and not invest it? I mean, it seems to me pretty clear that she made certain decisions about that trust. I'll let you answer, and then we'll hear from the other side.
Thank you. Just because the trustee kept records in one file doesn't mean that it necessarily kept proper records in another. So I don't think it's fair to look at the Children's Trust and to extrapolate from that the trustee, that the admitted absence of documents in the 5462 is the result of anything other than the trustee's failure to keep that. Did you want me to explain the
No,
tax
you can
issue?
do that. You can do that on your rebuttal time. Counsel?
Good afternoon, and may it please the court. Charles Keeley for the respondent, J.P. Morgan. Appellant argues that a trust that his great-grandmother has created for her own benefit in 1927 must be presumed to still exist today, despite an extensive record showing that it terminated 80 years ago. According to appellant, based merely on the fact that he has—
What are the extensive records? Could you please list them for me?
Your Honor, as the surrogate court states in its decision, there is a voluminous and continuous decades-long record of active engagement between the trustee, Elizabeth Sanchez, her children, and later descendants.
But not with respect to the trust at issue here.
Up until March of 1940, there is, Your Honor.
Well, but you said there are extensive records implying that there was some after that, after 1940.
Up until March of 1940, Ms. Sanchez and her two oldest sons.
So the issue here is what happened after 1940.
After 1940, Ms. Sanchez and her two oldest sons continued to correspond extensively with the trustee. But unlike before 1940, there is not a single mention of Trust 5462.
So there's no records with respect to that trust after 1940.
That's
period.
correct. That's the absolute last mention of the trust is that March 25th, 1940 letter, in which she instructs the trustee to leave the $60,900 balance in cash and uninvested.
So you rely on the absence of evidence as proof of the non-existence of the trust.
Absolutely not, Your Honor. It's the existence of a continuous and decades-long voluminous record and the absence of any mention of Trust 5462 within that record. It's inconceivable that starting in March 1940, everyone in the Sanchez family would have stopped mentioning the trust and would have forgotten about it, and it would have just disappeared for
And it was
for
the
decades.
same person at J.P. Morgan or J.P. Morgan's predecessors that was handling all of these trusts, the mothers and the 6 children, correct?
That's correct, Your Honor. During the time period at issue, Donald Bush was the trust officer who managed all of the accounts, including Mrs. Sanchez and her children's, prior to 1940.
It's puzzling, I'm sorry, I interrupted you, but it's puzzling to me why Mr. Bush wouldn't have had some kind of a document that memorialized the dissolution of that trust.
Your Honor, J.P. Morgan maintained records for all of the trusts that continued to exist after Ms. Sanchez's death in 1951. But a trustee does not have a duty to maintain records for trusts that terminate for decades after the termination and for generations after the beneficiary has died. The duty to maintain records is so that a trustee can account to the beneficiary. New York law, New York banking law, section 128, requires a trustee or a bank to banks or trust companies to maintain records for 6 years after account termination, not 60 years. So the idea that we're required to maintain records showing this counts, the revocation of this trust for decades and in eternity is unsubstantiated. They don't cite one case that supports that.
Am I right that at the time of Ms. Sanchez's death, her son, although offered by J.P. Morgan to have an accounting done, declined to have that done, and hence we don't know whether at that moment any documents may have still existed to show the termination or the revocation of the 5462 trust?
That's correct, Your Honor. When Ms. Sanchez died in 1951, the trustee contacted the children, including the sons, and stated its intent to account for the children's trust. The Emilio responded, don't account on our account unless you need to, because we know everything that happened in our trusts. There was no discussion after her death in 1951 of Trust 5462. If that trust still existed after her death, there is no way that her 2 sons, who were executors, who were well aware of this trust prior to 1940, would have just neglected to see to the distribution of this trust if it still existed at that time.
Thank you.
Thank you.
Okay.
There was not a single trust officer. There were multiple trust officers who dealt with the families over the decades that they had the trust. It wasn't Mr. Bush alone. There were many. With respect to the duty to maintain, that's if a trust terminates. So we have a circular reasoning here. They have no duty to maintain because it terminates, to which we say, show us that it terminated. So they're trying to escape having the obligation.
But that argument is somewhat circular in that they would not have been able to do that unless it was requested before 1950.
If there's proof of termination, irrespective of when it was, that should be in the file. Where is that request? It's nowhere.
Again, if they only have to maintain records for 6 years, right?
Yes.
And in 1940, March of 1940 was the last time that there was any mention of it. So they are arguing that that is the time of the revocation, since there was an instruction by Ms. Sanchez to hold the $60,900 that were in that trust in cash and not to invest it.
Sure, but to hold funds and not to invest is a whole different story than saying, I want to revoke it, I want to have it distributed to me. It was the exact opposite. She was saying, I don't want to invest those funds because of the investment situation in the country at the time. What's glaringly absent is anything saying, I want to revoke this, here's my receipt and release, any of those documents which would
No, but
establish that.
counsel, you can't, documents are not the only way you prove a fact, right? You can prove a fact without any documents. And so JP Morgan has said, here's what I've got to prove this fact. What have you got to disprove, or on the other side, to say that the trust kept going?
Well, first of all, the absence of proof shouldn't be proof. I understand what you're saying.
There's plenty of documents and conversations and everything else going on. So let's assume that you don't need a document to prove a fact. And JP Morgan has submitted all these emails and all these circumstances and all this other stuff. What have you got to refute that and say that the trust actually did continue?
We're at a huge disadvantage because we don't have any of those
I'm just asking you what you have. Any documents from the grantor? Any documents from her children? Any documents from anybody on your side showing that the trust actually did continue?
No, but the family has no obligation. The trustee had the obligation.
Got it. Thank you.
Thank you.
Tower National Insurance versus Joseph Lugo. You may proceed.
Thank you, Your Honor. Good afternoon. My name is Eric Tosker from Kelly Road in Kelly. We represent the defendant, appellant respondent, Joseph Lugo, and Michael Larson. Your Honors, in citing the case by Justice Getz, when he granted the motion to allow the affirmative defense of res judicata and collateral estoppel, Merrimack Mutual versus Alan Friedman, in that case, the subrogee had brought an action after the subrogor lost a small claims action. And the appellate division in that case held res judicata applied. And so not only is the affirmative defense proper and palpable, but we submit on summary judgment, the court should have granted the defendants excuse me. They should have granted the defendants a summary judgment based on collateral estoppel in this case. One World Wireless, they are the subrogee to, subrogor to Tower National. One World Wireless, in the first action they brought 2 years before the action was commenced by their insurer, went through discovery.
Of course, Tower argues that their interests were not represented in the One World litigation. Would you respond to that?
Yes, Your Honor, their interests were litigated in the sense that there was privity. Privity attached from the moment that Tower paid the subrogation claim that was made, I'm sorry, not the subrogation claim, the claim for first-party loss benefits that was made by by One World Wireless. They're stuck with whatever One World Wireless did.
They sort of make the argument, or there's the flavor of the argument, that One World took its foot off the pedal once it got the insurance payment from Tower, and so therefore didn't litigate vigorously against Lugo. Or was it only against Lugo in that case? Anyway, that's the argument. Would you respond to that?
Well, the argument, first of all, if they were concerned that that was the case, Tower could have intervened in the One World Wireless suit and not wait 2 years before they brought the subrogation action. So that's first of all. Secondly, if they're in privity, their rights derive solely from whatever rights One World Wireless had. So
what you're saying is once Judge Bluth dismissed the claims of One World, that was the end of that for Tower, and they had no other way. If they're stepping into their shoes were your case is dismissed.
To put it bluntly, yes, Your Honor. That's That is our position. I believe that's the law, and that Tower National would have they're stuck with whatever their insured had done or didn't do. And I submit that based on that, the summary judgment should have been granted with regard to the res judicata or collateral estoppel defense.
Okay.
But if I may have 2 minutes for the argument as to notice.
You have 1 minute. Go ahead.
1 minute, all right. Justice Bluth had it right. And there's no notice here. There were no water leaks. The One World Wireless witness, Mr. Singh, said that. Mr. Alugo had testified, the sink was renovated, it worked while they were there for 2 years. A year after that, Mr. Martinez was an occupant in that apartment, no leaks. There's no notice. Regardless of any claimed contractual obligations, Your Honor, there still needs to be notice, as Justice Bluth indicated in her order. And I would submit that while she did not consolidate the cases, in reading Tower's position, each and every one of the claims are addressed in Justice Bluth's order. So to say those claims weren't litigated really is not accurate.
Thank you.
Thank you, Your Honor.
You may proceed.
May it please the court. My name is Kevin Fitzpatrick, and I represent Tower Insurance Company in this matter. I think the first issue that is important here is that there was no privity here. Although we were the subrogee, we moved to, the consolidation motion was made, and then Judge Bluth denied the motion. Once she denied the motion, privity was severed, okay? There was no longer privity because we didn't have an opportunity to defend ourselves in that action.
You could have. You could have intervened, no?
No, if you look at this court's decision in Zimmerman, the court says you can assume that from a denial of a consolidation motion, that intervention would have been denied as well. Besides, consolidation was denied in July after the summary judgment motion was submitted. So had we moved to intervene after consolidation was denied, we would have been, what would we be intervened into? We wouldn't have been able to argue anything. The motion was already submitted.
And counsel, aren't you stuck anyway because your rights are derivative? You only have the same rights that One World had.
Up until we filed our own action, we only had the same rights.
Well,
Once we filed our own
you
action,
stand in the shoes of your insured.
Until
and
we
so
file
therefore
our
you
own
can
action.
only assert what they can assert.
Correct, until we file our own action. Once we filed our own action, we have different rights. We're seeking different damages. They were seeking damages that weren't covered under the policy. And as Your Honor said before, they took their foot off the pedal. And how do we know that?
That was the argument.
But if you look at Judge Getz's decision finds that had they asked for the proprietary lease and the sublease, which are documents that you would ask for in any case like this, they would have found this information that said that defendants Lugo and Larson maintained sole responsibility to maintain the plumbing. What makes that important is this was a $115,000 loss. This wasn't a drip in the ceiling.
Yeah, but that's not a strict liability provision. You still need notice, even if they have the responsibility for the plumbing, correct? Or am I missing something?
You're correct, you do, unless you go res ipsa loquitur. But let's go with the constructive notice argument. It's their burden to prove they didn't have constructive notice. Their own testimony was, we never examined the pipes.
They also said they never had any leaks.
But
and that they renovated in 2012.
That doesn't mean that there wasn't a latent defect there. We're talking about a $115,000 leak.
Yes, counsel. There's $115,000 of damage because an entire water valve was not shut off for over 40 minutes while the tenants tried to get the superintendents of the building to shut off the water main. So that's why there was such extensive damage.
But my point being that there wouldn't, if this was not a defect that could have been noticed.
We have no idea what it was. The plumber said that there was a valve problem, did not identify where the valve was. The valve may have been inside an internal wall or inside the basement of the building. We have no idea. There's no evidence about what valve malfunctioned, whether it was inside the apartment, underneath the sink, or inside a wall.
And that's
If
what-
it's inside the wall, this tenant isn't responsible for that.
But that's their burden to prove in a summary judgment motion. They didn't make that proof. They just said, we're entitled to summary judgment because we didn't have any prior notice of an existing leak. That's actual notice. That's not constructive. They were supposed to prove that there was no existence of a latent defect. They can't prove that if they never looked. They cannot prove that if they never looked.
The tenant said they lived in the apartment for 2 years, they had used the sink multiple times, and there was never a leak. What more is there to do?
They never noticed a leak. They didn't look.
Counsel, if
Nobody
there's
ever
a
looked.
leak, you notice a leak. They noticed it on this day.
Not on the sink. Well, if your honors were able to see the video that we have of this, the water was shooting out through the ceiling.
Like I said, a water main valve did not get shut off.
But I'm saying that's why they noticed it on the day of the leak, not because that all of a sudden they became proactive. They never looked under the sink, so they never ever knew if there was a little drip. They never knew if the valve was starting.
What does a little drip have to do with gushing water coming through the ceiling of the store downstairs?
Because
the two are not even connected, Counsel.
The water
You're
leak,
arguing apples and oranges.
the water leak was under the sink in their apartment.
Okay, got it. Thank you. You got 1 minute?
Yes, I just want to address for a moment the case of Zimmerman that was cited. And I think we're comparing apples and oranges when we compared the Zimmerman case to the case at hand. Zimmerman, in that case, the rights do not derive to sue under the insurance contract, at least back at that time. The statutory right under 3420 of the insurance law didn't derive until the accident, the judgment, and then the judgment goes unsatisfied. It's only then that the rights of the insured under the insurance contract would derive to the personal injury plaintiff. In this particular case, the rights of Tower derived from the moment they made payment back in 2016, and highly distinguishable. I rest on the briefs as to my other arguments, Your Honor.
Thank you.
Thank you.
You have 1 minute.
Just on that point, I refer the court to my main brief at page 11, where we quote Zimmerman, where it specifically says that the reason why there's no privity is because consolidation was denied, and therefore that person didn't have the right to appeal. It has nothing to do with where they derived their insurance rights from. It's a question of whether or not they had an opportunity to be part of that first action. So it has nothing to do with the derivation of where they get their right to sue. It has to do with whether or not they had the opportunity to participate in that first action.
Thank you.
Thank you.
People versus Sanius. You may proceed.
Yes. Good afternoon, Your Honors. I may please the court. John Vang for Jaquan Signius. Your Honors, in People v. Rothman, this court ruled that there is a constitutional limitation on a court's authority to submit a lesser that represents a significant departure from the people's theory of prosecution. The trial court violated that rule here by granting the people's request to submit general intent burglary as a lesser, dramatically altering the people's theory of burglary. Now here, the people from inception had narrowed their theory of the case from the grand jury minutes to indictment, even up to the minutes of the Molyneux application, where the prosecutor stated very explicitly, this is a few days right before trial, quote, our theory, and this is page 25 of the voir dire transcript, our theory is when he crossed that boundary, he committed a sexually motivated burglary. He entered unlawfully into the dorm with intent to gratify his own sexual desire, and that is the substance of the burglary charge. Then the prosecutor continued to open on that theory. Now, relying on that narrowed theory of intent, the defense opened on theory that the evidence did not, in fact, show that he had this specific intent to commit any kind of sex offense inside. Then the defense crossed all three witnesses on that theory. Mid-trial, after all this happened, the court granted, first of all, the prosecutor asked for the lesser of general intent burglary, and then the court erroneously granted that request, notwithstanding counsel's persistent objections. Now, it doesn't appear that the court actually appreciated the Rothman error here. The record suggests that the court granted the people's request after they handed up cases indicating that this general intent burglary legally qualified as a lesser. But again, under Rothman, even if it's a valid lesser, the court cannot charge it unless it cannot charge even a valid lesser if it changes the people's theory of the case as it did here. So under Rothman, the lower court exceeded its authority in charging the burglary charge, and the burglary conviction should be
Let me
reversed
just
and dismissed.
clear up a couple of things in my own mind.
Sure.
Are these two crimes both B felonies or C felonies? I know they've reclassified some crimes.
I mean, yes, they're violent felonies, yeah, yes.
So what classification are they? A, B, C, what?
I believe they're C violent felonies.
Both C violent, right?
You know,
Well,
honestly,
they're both the same classification, am I correct?
yes, right.
Okay.
Unless your honors have any further questions, I ask that.
Well, you know, when I was reading it, I was saying to myself, gee, you know, usually a lesser included is a lesser crime.
I'm sorry, Your Honor, I didn't.
Usually a lesser included
Right.
is a lesser crime.
Right, yes. I mean, this
But
this
these
is,
crimes are the same classification.
well, what this does is actually, the sexually motivated felony component allows the court to enhance the sentence. So it's really more of a sentencing enhancing thing. But what happened here in this
And
case.
it allows them later to require
Exactly.
or
right. Yeah, so that's what it is. It's a sentencing enhancement component. But what happened here too was that, and again, this doesn't happen in any case, every case. It's not a per se. It doesn't per se mean that the people are proceeding on a theory that, you know, the intent was to commit a sex offense. But in this case, as reflected in the evidence before the grand jury, the people's theory of burglary here was that he entered with the specific intent to commit a sex offense inside. Having advanced that theory persistently.
But are you saying that because the people advanced that theory, both in their presentation to the grand jury and at the trial phase, that a jury could not listen to these facts and determine, okay, well, I think he went in to commit a crime, but I'm not so convinced that it was sexual in nature, and therefore I'm going to convict on the straight burglary rather than as a sexually motivated offense?
The court.
Why is that not permissible under these facts where the defendant was acting so erratically, so strangely in the street, approaching people and intimidating people as they walked by, grabbing at women, etc.? Why could the jury not have just thought perhaps he wasn't all there? And so I'm not so convinced that this was sexual in nature as much as he's not operating on all cylinders, as it were.
And you're right, and Your Honor, that's exactly what the jury did. The jury acquitted him of the top count. But I think the error here is not that. The error is not what the jury could have done. The error here is the court holding the people under the Constitution to the limitations that they placed on their theory of the case.
Yep.
And it cannot change it to the defense's detriment mid-trial after the defense had already crossed all witnesses, opened on a theory saying that there was no specific intent here, to the defendant's detriment. That's the legal error here.
But all they have to prove for a second-degree burglary, plain old second-degree burglary, is that he intended to commit a crime when he entered.
Right, yes.
Correct?
Yes.
The fact that they wanted to try to prove that more than that,
Right.
and they weren't successful, I don't see how that's an error in law.
Well, when they narrowed their theory, under Rothman, when they narrowed their theory of intent to one, as here, as I explained before in the Molina application, when they narrowed their theory of intent to a very specific one, and this is consistent with this court's cases in McCleary and other appellate division cases in Colliamper, when the people narrow their theory of intent as to burglary, they are obligated to prove that theory. And here, there is a constitutional limitation that prevents the court from granting a lesser that changes the people's theory of intent, as here, mid-trial, to the defendant's detriment. And that is the legal error here.
Okay.
Thank you.
You may proceed.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. I want to address this, the issue raised by my adversary regarding the people's theory in this case. The people's theory was quite simple, that the defendant entered the dormitory unlawfully with the intent to commit a crime, and that the purpose of doing that was for his own sexual gratification. As this court has held in Rodriguez, ordinary burglary...
So your theory of the crime was that he intended to commit that particular type of burglary, the sexually motivated felony.
Correct, that he unlawfully entered with the intent to commit a crime.
So when the jury said he didn't do that...
Correct, and I think as Your Honor noted, that was based on evidence of...
I haven't quite finished it.
Okay, my apologies.
When the jury decided that he didn't do what your theory was, what is it that you proved that he entered to do?
The evidence proved that he entered the dormitory to commit a crime. They never, the prosecution never submitted a theory of what that crime was. And in fact, the evidence showed that he had committed multiple crimes, both in and outside the dormitory. And so...
What were the multiple crimes inside the dormitory?
Well, the evidence does show that as he is unlawfully entering the dormitory, he is pointing at students who are sort of beyond the elevator area.
Well, that's not a crime to point at someone.
No, but the evidence also shows that obviously he had been doing that outside. He'd also been grabbing people, harassing people.
Did he grab anyone inside the dormitory other than the particular person or the particular?
Yes, he grabbed multiple students inside the lobby of the dormitory as he's entering, and as he and the security guard are confronting each other, more students enter the dorm and he tries to grab them as well. And so the evidence would have shown that he entered through the turnstiles. Again, the prosecution never submitted exactly what crime that was going to be on the other end, but that it was a general intent to commit a crime, and that the purpose of that was for his own sexual gratification. And as
you keep going to the only purpose of that was for his own sexual gratification, but the jury wasn't persuaded that that's what he did.
That's correct, Your Honor. The jury...
So where does that leave us?
Well, Your Honor, I would go back to CPL 300.50, which simply says that if there is a reasonable view of the evidence that a lesser included was committed but not the greater, and that lesser included is in fact a lesser included, upon the party's request, the court has to submit that charge to the jury. That is precisely what happened. There's no abuse of discretion here, unlike in the Rothman and Garcia cases, where those are very unusual circumstances as well, I just point out. In Rothman, the people had actually withdrawn their initial submission of charges that the court then sua sponte added back in and then charged the jury on. In Garcia, the conviction was at a bench trial, and the court essentially said, I am going to now charge myself on a lesser included offense that the people did not ask for, that the defense did not ask for, and that I am going to find the defendant guilty based on facts that the people had not pursued in their case in chief. So those cases are very unusual from this case, where the people actually requested it, and this court has already determined that although they may be classified the same, ordinary burglary is a lesser included offense of ordinary burglary as a sexually motivated felony. And so under that two-prong analysis, there's really there's nothing further for the court to do at that point other than to submit the charge to the jury. Unless there are any other questions, we ask that you affirm. Thank you.
Thank you so much.
I'd just like to make clear, this error, the first error is not about whether there is a reasonable view of the evidence that he committed the lesser but not the greater. This is a very different error. It's even if there is a reasonable view, even if it is a valid lesser, the court cannot charge it under the Constitution if it represents a significant departure from the people's theory of prosecution. Now, my adversary today on appeal in oral argument is now distancing themselves from the very consistent theory of prosecution, which the people stated in their own words in their Molyneux application, and they continued to repeat later in summation that their theory of the case was that this was a case of entry with specific intent. Now, my adversary points out to the evidence showing Mr. Signius grabbing other people, but he also doesn't point out that it shows him grabbing women, which suggests, again, that the people's evidence is indicating that he is entering with a specific intent to, continue his sexual abuse inside. Having narrowed their theory in that way, they should have been held to it. This burglary count should be dismissed. Thank you very much.
Thank you. Lanza versus Kaiser Gypsum Company, and was that submitted? Sorry. People versus Espada. That's good. You may proceed.
Good afternoon. My name is John Palmer, appearing on behalf of Joseph Espada. The officers in this case pursued and forcibly stopped Mr. Espada without reasonable suspicion that he was involved in any crime. They initiated this pursuit based only on the observation that they saw a man arguing with a CVS employee inside a store, ran from the store, and was followed by that employee. This court has not found reasonable suspicion under such equivocal circumstances. Accordingly, we ask this court to reverse Mr. Espada's convictions.
Why isn't that flight combined with specific circumstances, like People versus Sierra, for example? Why, I mean, you've got a flight, and then you have an altercation. One of the officers recognized Mr. Montgomery, I think, was a CVS worker. And
Right,
knew that
he
worked
did
at
recognize Mr. Montgomery as a CVS worker. This altercation did not provide indicia of criminality. For example, in Sierra, as Your Honor mentioned, in that case, there was an apparent drug transaction, and the defendant refused to approach the police and then fled from the police. That provided reasonable suspicion. In the other case under Sierra, for example, there was a waistband grab during a taxi cab stop in which the defendant was a passenger, and there was no information related to criminality, and then the flight did not amount to reasonable suspicion.
Counsel, let me suggest that over the last few years, this court has seen an absolute inundation of cases from Dwayne Reed and CVS exactly like this, okay? And so it is not uncommon anymore for police in our city to pay attention to altercations or heated arguments between CVS or Dwayne Reed workers and the public, okay? So let's say that there was enough going on for them to come and find out what was happening. So instead, I'd like you to focus on the excessive sentence issue.
Sure, Your Honor. The 18-year sentence in this case is excessive. The circumstances of the offense, although serious, did not warrant an 18-year sentence. For example, the circumstances include that there was no physical injury to Mr. Montgomery. The only physical injury in this case was the minor injuries that Officer King suffered when he slipped past Mr. Espada while tackling him. And consistent with these circumstances, the prosecution only recommended sentences as low as 5 years and 8 years.
What was the minimum, counsel?
The minimum in this case was 8 years. And that sentence would be sufficient here.
When you say the prosecution recommended, when did they recommend that? As a part of a plea bargain or?
But as part of plea bargains, yes, Your Honor.
Not at sentence. What did they ask for at sentence? Do you
They asked for 18 at sentence. And then further, Mr. Espada did have a criminal record, but his record should be considered within the context of his background. Mr. Espada struggled with addiction from a very early age. He was born with cocaine and heroin in his system, and he tried heroin before the age of 16, and his first conviction came at the age of 19. He wanted to experience homelessness as an adult. And despite these lifelong struggles, he never received adequate treatment. But in the 17 months between his arrest and sentencing, Mr. Espada took affirmative steps toward rehabilitation. He voluntarily participated in a cognitive behavioral treatment program proven to reduce recidivism, and he took courses geared toward his issues. Substance abuse, mental health, relapse prevention, and building job skills. And in letters to the court from the program, staff found that Mr. Espada showed tremendous growth and a motivation for change. And beyond that, he was a role model to his peers, taking time to become invested in other people's growth. And for those reasons, 8 years is ample time for Mr. Espada to complete that rehabilitation. We ask this court to reduce his sentence in the interest of justice.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Carrie Fulham on behalf of the people. I'm fully able to address the suppression issue, but given the current focus of this court, I can move to the sentence if Your Honors would prefer that.
I'd appreciate that.
Your Honors, on its face, an 18-year sentence here looks like a very long sentence.
For 5 or 6 tubes of toothpaste, you better believe it.
I fully understand Your Honor's point of view there. And of course, this court has the interest of justice jurisdiction to reduce the sentence if Your Honors feel that that's appropriate. But with the court's indulgence, I'd like to take a minute or two to discuss the reasons why the trial court thought a substantial sentence was warranted here. First, this was a violent and threatening crime. Defendant was convicted of a Class B violent felony that carried a maximum penalty of 25 years.
Counsel, if he did not pull out that syringe, this would be a misdemeanor case and we wouldn't be here. You and I both know that, okay? No one was hurt, all right? And so I am not at all condoning the stealing of toothpaste. But to send a grown man to jail for 18 years for toothpaste is just outrageous and seems to me to be kind of tone deaf in terms of where we are supposed to be going in this nation on this issue.
Your Honor, I completely understand. Absolutely. You and I completely agree that had defendant not pulled out a syringe, this would have been a petty larceny. And that was a factor.
I mean, if we have murderers, people who actually take somebody's life that don't get 18 years. So explain to me why we should uphold such a draconian sentence.
Your Honor, Your Honor, I recognize the interest of justice jurisdiction here. I fully understand that if this court wants to reduce that sentence, it has the power to do so.
Do you agree that the minimum was 8 years?
The minimum, yes, was 8 years at conviction.
Can I just ask, what caused the trial court to raise it to 18?
So a few things, Your Honor. First, the court considered the facts of the case, which wasn't a petty larceny. There was a threatening and a use of a dangerous instrument, as well as a nearly 30-year span of criminal history that this defendant had.
Was that criminal history all based on his addiction?
Your Honor, that's not for me to say.
Well, we can tell from the cases that he's been convicted of, right?
Yes, certainly he has prior convictions of drug use. However, there were violent convictions here as well, a gunpoint robbery, a knife point robbery where there was no indication that drugs were involved, second-degree assault, attempted second-degree assault. And actually, Your Honor, although there's been this allegation that the defendant might have been under the influence of some drug at the time of the incident offense, the PSR flatly contradicts that. And so taking all of that into consideration, the judge thought a substantial sentence was warranted here. And I'd also like to say that defendant does not challenge the length of the post-release supervision time. So if this court does reduce the sentence, the people would ask to uphold and keep the 5 years of post-release supervision intact.
Okay.
I can...
If you have anything else, I don't want to cut you off. You still have time.
No, I would just like to distinguish the argument about the trial tax versus the pre-plea discount. And the 5-year sentence that was originally offered was pre-plea. Then there was an 8-year sentence the people offered that was right after the suppression hearing. Then still before the trial, the people said in the range of 15 years. So there were certainly prior offers made to this defendant, but that was in a different context. That was a discount for accepting full responsibility. To date, defendant has not accepted full responsibility. He refuses that he was guilty of the top charge, first-degree robbery.
Thank you.
People ask you to affirm.
Just very briefly, Your Honor. Yes, Mr. Espada did have prior offenses over a 30-year span. But as Your Honor pointed out, that a lot of these offenses are poverty-related.
Is he about 50 years old now? Is that correct?
What was that? I'm
Is
sorry.
he approximately 50 years old now? Is that?
Yes, I believe he is 52 years old currently. And he will be in prison on 18-year sentence until he is almost 65 years old. And again, most of its offenses are poverty-related. And counsel mentioned a gunpoint robbery. defense counsel below noted that the rap sheet, based on the rap sheet, was not so clear that's actually a gunpoint robbery, and that it specifies a subsection. In any event, Mr. Espada taking responsibility, this was a trial case, and Mr. Espada had a appeal coming. It's perfectly reasonable for someone not to take full responsibility when they believe they're innocent of some of the offenses they were charged with. Additionally, in the PSR related to intoxication or influence, Mr. Espada was not interviewed for the PSR. He refused to be interviewed, actually, in this case.
Okay.
So I'd ask this court to reduce Mr. Espada's sentence in the interest of justice.
Thank you. Chen versus 111 Mott. You may proceed.
May it please the court, my name is Nicholas Herzler, and I represent the appellant in this matter. Your Honors, this is simply a case where there's so much evidence of the workers' compensation bar applying to my client. The record is absolutely replete with it. We moved for it way in advance of trial. Under Court of Appeals precedent like Murray and Caceres, this could only be waived after a trial on damages, which we were nowhere near. My adversary, the plaintiff, claims there's no evidence of the fact that H&M was his employer, even though Mr. Huang testified to that, even though Judge Sawyer found that, even though he applied for those benefits, even though he got those benefits. It's mind-boggling to me that the plaintiff could take that position that there's no evidence of it. And as for 111 Mott, they claim, well, it doesn't apply because we weren't there at the workers' compensation hearings. Our point there is we're entitled to a dismissal of 111 Mott's cross claims just because under the case law, what matters is whether the plaintiff had his benefits, whether he applied for those benefits. There are cases like Murray, Delgado, and all these numerous cases that we cite in our brief. It's not up to the co-defendant and any co-defendant to contest that type of ruling made by a workers' compensation board. And if they were entitled to that, it would lead to inconsistent rulings. If we're entitled to a dismissal of the plaintiff's complaint, then how could they contest that and then get an inconsistent ruling on that? It just doesn't make any sense. And they don't cite any case law. They talk about collateral estoppel, but they don't cite any case law where a co-defendant can contest a workers' compensation ruling after a plaintiff's complaint has been dismissed based on evidence that the plaintiff obtained those benefits.
Would it have been any different if the plaintiff had not been at the workers' comp hearings and was asked if they had a position and they took no position? I mean, if they had not been there, if they had taken a position, would any of that made a difference to the collateral estoppel issue now?
I don't think so, Your Honor. I mean, I think it's kind of like icing on the cake. I mean, for a plaintiff's attorney to be at the hearing and say, we take no position on that, and then they accept the benefits, like, I just don't see how you can do that and then turn around and say, as they say in their brief, well, it's our policy that we don't, care about that or something like that. Like, I don't care. It doesn't matter what your firm's internal policy is as far as like how you deal with something. It's just but that's the law. The law is that if you are aware of benefits and you accept benefits, you cannot sue your employer. That's just the way the law is. I mean, they say that it's prejudice, and yet, their idea of prejudice is that they can't get benefits and sue their employer. But the legislature, in its wisdom, passed a statute that says they can't do that. So, all I'm asking for here, I don't think is a lot. All I'm asking for here is a complete dismissal of the complaint and all cross claims against my client on the ground that clearly the bar applies. Unless the court has any questions, I will rest.
Thank you.
Good afternoon, Your Honors. My name is Michael Altman with the Altman Law Firm, and I'm appellate counsel for plaintiff respondent. I want to jump into this, but I would like to reserve about 1 minute on the labor law cause of action and about 15 seconds on indemnification. What was missing from the presentation, and what to me is mind-boggling, is that the party that's asserting in this action that, or on this appeal and on the motion, that they employed Mr. Chen, produced one witness in this case. That witness was the general manager or manager.
You're talking about Mr. Leong's testimony, right?
I'm sorry?
Mr. Leong, I'm probably mispronouncing his name, but he's the person who said that the plaintiff was not our employee, right?
He's the person who said it, and he's the general manager of the company.
Now you have an adjudication from workers' comp, so.
Correct.
But is it,
and he
and
took
not
this-
only do you have an adjudication, but is counsel correct that your client has been receiving workers' comp benefits?
Absolutely.
So how can your client be receiving workers' comp benefits, accept them, and then say, oh, but this was not my employer?
Okay, because he has consistently maintained that position, and that was the position of H&M before the Workers' Compensation Board, and it was their witness's position in this action. He testified unambiguously. The Court of Appeals in Casares and Murray said that even where a plaintiff receives workers' compensation from the employer, the court has the discretion to still deny the application for, to assert the comp defense. Now, I understand that in 99% of the cases, there's going to be preclusion, and there should be. But in 99% of the cases, the party doesn't come into court and have their witness say, a deposition, and have their witness say, we didn't employ him. They don't go before the Workers' Compensation Board and say, we don't employ him. And Mr. Chen explained that he was employed by a Mr. Wang, and the documentary evidence shows that Mr. Wang worked for the subcontractor of H&M. This is an incredibly unusual case, and it's our position that it's only under such incredibly unusual circumstances the court would have the discretion to not allow the defense. If
So
they're not going
counsel,
to be
let me
allowed
just,
to do...
counsel, this is me over here. So what you're saying is the court could find that he, even though the Workers' Compensation Board found that he was an employee of H&M, you think that it's okay for the lower court to find something else?
Absolutely, that's
And
what...
those inconsistent, and then how do you distinguish all of our cases that say you litigated this issue. Everybody litigated this issue in front of the Workers' Compensation Board. There's a finding, and that finding is entitled to collateral estoppel effect, right? Grauman, Vogel, all those cases. How do you distinguish all those?
Right, because in all those cases, the plaintiff was employed by the person found to be the employer. But here the employer said it didn't employ him at the workers' comp proceeding.
No, that's not the linchpin. The linchpin is there's a workers' comp judge finding. It doesn't matter. No one goes before the Workers' Compensation Board to dispute coverage if they think that they're not the... that's part of the proceeding, is who's the party's employer. The fact that this H&M disputed it doesn't mean that there wasn't a finding that's entitled to collateral estoppel effect, right?
Except that the Court of Appeals said in Casares and Murray that there can be times that it doesn't apply, and this case...
And in that case, how does that mirror this one?
I'm sorry, Your Honor?
The Casares case. How do the facts in Casares mirror this one that we should apply it in the same way?
The facts don't, and in fact, in Casares, the defense was allowed properly because there the plaintiff knew who his employer was and knew from the inception of the action. That's what makes this case so unusual. And I try to affirmatively get out there that I understand that in I think I said 99% of the cases, that the plaintiff will be precluded. But this is just an unusual situation. And if the court...
I really don't see what's so unusual about this situation. As my colleague just pointed out, the fact that there had to be a workers' comp hearing is indicative of exactly these type of adjudications. But we're out of time.
Okay, may I address the labor law claim for a moment?
No, we're out of time.
Thank you, Your Honors.
You have 4 minutes, counsel.
Thank you, Your Honors. Beth Garrick for the defendant respondent. I'd like to draw the court's attention to the Batten case, B-A-T-E-N. The site is 85 AD 3D 697. I recognize it's from the Second Department from 2011, but I pulled it from the appellant's brief. That case is directly on point. And in that case, a similar thing happened, as happened here. There was a finding of an employer-employee relationship, and another party, such as the owner of the property, which is who I represent, did not have a full and fair opportunity to litigate the issue. And in that case, they found that Capital One, who stands in the same shoes that I do here, should not have been precluded from litigating the issue of whether Riggs was the plaintiff's employer. The main problem I have here is they waited until after discovery was complete. They waited until after we moved for summary judgment and plaintiff moved for summary judgment to first turn around and ask to amend. That was prejudicial to us. And we showed in our brief.
How is it prejudicial?
Because we would have brought GD into the case. We would have had claims against GD. We would have done discovery against GD. We would have moved to dismiss based on their failure to name an indispensable party. But their witness showed up. Now, we have no knowledge of what happened at the workers' comp. I'm sorry, stuff's going in my mouth. We have no knowledge of what happened at the workers' comp proceeding because we weren't on notice. We didn't have the opportunity to question everybody. We didn't have the opportunity to elicit facts that may have shown that the control over here was by GD, not by H&M. And H&M's position all along in this case, and actually before the Workers' Compensation Board and at the appeal to the three...
H&M was the GC though, right?
Correct. And they said, we didn't employ him. And when they appealed, they said, we're not the employer. Their manager, their general manager testified, I didn't employ Chen. He actually said GD is the one who employed them. Based on his testimony, their testimony, we couldn't bring GD into the case because they were the employer. And
well, I mean, but that hadn't been decided yet. I mean, obviously, I was looking at the depositions of various people that appeared for deposition in this case, and there was different testimony as to who was the employer, whether they were getting paid by cash, whether they were getting paid not by cash. So there was, that's why they went to the Workers' Comp Board, I guess, to have a determination made.
Respectfully, Your Honor, every single witness in this case, in the third-party action here, testify, as opposed to the Workers' Comp, every single witness testified that H&M was not his employer. And I think that's important. And I think this seems to be a little bit of an MO going on here with defense counsel, the appellant, because in their papers, in their reply brief, for the first time, they bring up the indemnification issue. They didn't bring it up in their main brief. They didn't bring it up until it was too late for us to address it. Similarly, they did not bring up the potential for this defense until discovery was complete and it was too late for us to address it. So I ask that the court look at the Batten case, and I think that it is...
How long did they take after the workers' comp hearing decision to move to amend? Because they clearly couldn't do it before that.
Oh, many years. It was, the workers' comp decision was in 2017. September 7th, 2017 is what, sorry, that's, may I?
Go ahead.
Okay. The original decision was May 30th, 2017. It was affirmed by the full board on September 7th, 2017. And they didn't take a further appeal at that point, going up to the third department, which if they did, then we could have intervened and possibly been able to participate, and then they could have said it was binding on us. That didn't happen. They then did not move to amend until September 25th, 2019, so we're looking at over 2 years.
Okay, and under the law, they're permitted to still move. They haven't run out of time under the law, correct?
Unless there is prejudice shown, and here there is prejudice shown. The Court of Appeals has said you have to look at the realities of the litigation, and the reality of the litigation here is We couldn't have done anything at the Workers' Compensation Board. We couldn't be heard there. However, here, they tied our hands by waiting until the last minute. Whether it was a litigation strategy or something else, I don't know. They gave no excuse. They did not say why they waited so long, but by waiting so long, we were prejudiced, and as a result, because the trial court has broad discretion, and this court usually does defer to the trial court in these situations, we'd ask that the decision below be affirmed.
Thank you.
Thank you, Your Honors.
You have 1 minute, counsel.
I'll just make a few brief points. There was a lot of discussion about Lee's testimony at the workers' comp hearing and his deposition they heavily rely on. My point there is, as I argue in the brief, it's a judicial estoppel argument, which doesn't apply if you lose at the first hearing, which is what happened here. You can change your position if you lose in the first hearing. And under the case, we have a lot of cases on that, such as Jones.
Counsel,
Lang.
you're not arguing collateral estoppel against the other contractor, right? You're only arguing as to H&M.
No, we are. We are arguing.
They didn't know anything about it. How could they possibly be collaterally estopped?
They can, first of all, they process authorizations for the workers' compensation records.
Did they have an opportunity to present any information or at that hearing?
Of course, they have a whole course of discovery. They know that there was a workers' compensation board hearing that went forward. They know that there's a published decision that went up on appeal and was affirmed. They know all that. They're on notice of all that. And we have until the end of a case on damages under Murray in order to move to amend.
Okay.
Thank you.
Thank you.
Okay. John DeLeo versus JP Morgan Chase. You may proceed, sir.
Good afternoon, thank you. May it please the court, I'm Mitchell Sassauer from the law firm of R.E.A. Lustig and Sassauer, attorneys for the plaintiff's appellant. With respect to the Labor Law 241-6 claim, the plaintiff is walking 10 to 15 feet down a hallway, and that hallway is a passageway, and he passes various items of debris. Among those items, ceiling tiles, metal studs, pieces of pencil rod, screws.
Counsel, he said that those were all on the side until he got to the Snapple cap, correct?
Yes, sir. Yes, Your Honor.
Does that make a difference?
No, because those items that he passed that were on the side, in the aggregate, represent an accumulation of debris. And then he slips on the Snapple cap, and the Snapple cap happens to be in the middle of the hallway, but it's the same hallway. And it is more debris, so it is therefore another item of debris that represents part of the accumulation of debris. And the Snapple cap that's in the middle, being all debris and all in the same passageway, should be counted in the aggregate as opposed to doing what it is that defendants always do, which is to try to look at each item in isolation. So the defendants will always say, we can't be responsible for every single cap. We can't be responsible for every pencil rod, but that's not what the rules talk about. The regulation, which is to be, of course, construed to promote the legislative intent to ensure worker safety, that's a rule that says that when you're looking at the debris, look at it in the aggregate. That's why they talk about an
What about
accumulation
Vital?
of debris.
I'm sorry to interrupt you, counsel, but in Vital, of course, there was a sandwich wrapper that the plaintiff slipped on, and this court found that it was not debris, but rather
They refer to it-
transient. It was transient. And so was the Snapple cap transient here in that it was the only thing that was in the middle of the walkway?
The difference between, with all respect, with the difference between the Vital case and the case at Bar is that that transient condition was in an exposed rooftop, which was open to the elements. Here, the Snapple cap is in the middle of a confined job site where the only people who are on that 13th floor are workers. Everybody on the 13th floor where the accident occurred is a worker who is under the jurisdiction of the general contractor, and therefore the general contractor is responsible. Now, when we're talking about the debris being, the Snapple cap being in the middle versus on the side, for all we know, another worker could have gone by, inadvertently kicked it, and moved the piece of debris from the side to the middle. It's possible that a laborer, in moving or pushing the debris from the middle to the side, instead of removing it, may have inadvertently left the Snapple cap. And it can't be that the protection under Labor Law 241-6 and regulations which are supposed to be construed to promote worker safety can depend on such a fluke as to something like that. And so we submit that it's the same passageway, it's more debris, and therefore should be counted toward the accumulation of debris in that same passageway. Now, I think that part of the problem here with the lower court is that the plaintiff almost has the bad luck of it being a Snapple cap, and it sort of sounds almost silly. You know, it's not real construction debris. As to that, I think it should be clear that the safety director for Plaza said that food debris counts as any other debris, and this debris should be counted that way. The other error we respect that we submit that the court made below is on the question of whether 1.7e covers slips as well as trips. The court took the position that as he slipped and therefore he didn't trip, and so it should not be covered, but the precedents of this court, Pereira versus New School versus Flintlock, that Maria versus Airbnb, all make it clear that that should not be the distinction here. And what we're looking at then are facts that are really not in dispute, and when the undisputed facts show that the plaintiff slipped and fell under debris, under circumstances which would be a violation of the regulation, and no one's disputing those facts. Their statement of fact looks very much like our statement of facts. And under those circumstances, we should be entitled to get summary judgment on our cross motion under 241-6. And I can address to...
You can address it on your rebuttal time.
Thank you
okay?
very much, Your Honor.
Great. All right, counsel, I'll hear you.
Good afternoon.
Good afternoon.
May it please the court, my name is Lauren Donnelly, and I represent the defendant and respondents in this case. At the outset, it should be noted that in the underlying papers, in the bill of particulars, plaintiff only relied upon Industrial Code Provision 23-1.731 and 2. In reply, on this appeal for the first time, they allege a violation of 23-1.7D, which relates to slipping hazards. That argument should not be considered by this court. It's unpreserved for judicial review.
Counsel,
It's
you're
highly
saying the other
precedent.
provisions only apply to tripping versus slipping? Is that what this distinction is?
I don't think it, I think,
Because I don't agree with that. I'm just
Okay.
giving you a heads up. There's lots of our precedent that we don't make that distinction anymore.
yes, you're right. The court did find that it's tripping, and there is case law in this department that does apply it to slipping. So, but if you, even if you consider it to apply to a slipping situation, this is not a case of an accumulation of dirt and debris. It's a single bottle cap, a transient
Except
condition.
that this was an ongoing problem. I mean, this is not like some of the cases we see where on a particular day there was a bit of a mess. This was an ongoing problem such that he complained about it at safety meetings several times. So the argument that this is just a transient cap kind of falls flat in light of this record.
I disagree, Your Honor, and because every time there was a complaint made, the condition was cleaned up immediately by the general contractor's laborers. This was not a dirty construction site. It was a construction site. So, but they had laborers on site on a daily basis, there to clean, and the superintendent indicated as soon as he gets a complaint, the laborers are called and they go and clean it up. And plaintiff
You
himself.
haven't disagreed with what I said, quite frankly. You've just.
I'm not, but
You've
I'm.
confirmed what I said.
No.
That there had been ongoing issues with laborers not cleaning up after themselves, such that this plaintiff had to complain about it. And I agree with you. The record shows that when he complained, people came, the GC's laborers came and cleaned it up. But there was an ongoing problem with messy workers.
The testimony here is the site safety person from Plaza went there, and if housekeeping was a regular issue, it would have been noted on their agenda. It was not included. None of them recalled any complaints about housekeeping. And if you look at plaintiff's testimony, he specifically stated that the bottle cap was the only thing in that area. There were only things on that 10 feet, a few things here, a few things there. That's not an accumulation of dirt and debris, which is the intent of this particular statute.
Oh, is that an issue of fact?
No.
Some dirt here, some dirt there, that's not an accumulation? That sounds like a fact issue to me.
I don't think it's a fact issue based upon this record. It was a single bottle cap. And in terms of...
Well, the single bottle cap is what he fell on, but he did say he observed other items on the floor, albeit off to the side.
But he also testified that, yes, he did see it, but it was insignificant, small, and did not warrant a complaint. So in terms of the 241-6, that should be affirmed, the dismissal. As it relates to Labor Law 200, there's no evidence that anyone had actual or constructive notice. The bottle cap was not visible nor apparent.
I go back to the same statement. There was an ongoing issue about cleanliness, so why isn't that sufficient to create an issue of fact, at least on the 200, of not maintaining the property in a non-dangerous condition?
There's really, while the plaintiff did make certain complaints, again, he testified that no matter, whenever there was a complaint, it was immediately cleaned up. The laborers were on site. They had a site superintendent there, and also the Unity employees had responsibility to clean up after themselves. This was not one of the construction sites where the testimony indicates that there was debris all over the place at all times. And if there's no other questions, I'll rest on my brief.
Thank you so much.
Thank you.
Okay, counsel, you have 2 minutes. Can you address the Section 200 claim?
I will at that. 200, quite correctly, brings into focus issues of notice. And if we were making a motion for summary judgment under Labor Law 200, then the burden would be on us at this point in this proceeding to show that there was notice. But it was the defendant's motion for summary judgment. And this is a situation where the burden was on them to show an absence of notice. And the case law is clear. The Sabalza case is right on point and makes it clear that once the defendants fail to show the last time that the area was cleaned or inspected, that failure makes the motion defective on its face. And so this is a situation where, like the court referenced in Sabalza, the court below seems to have focused on gaps that they see in the plaintiff's ultimate proof at trial, but that's not what we're looking at here. First off, we believe that we could probably establish notice at trial. But on this motion, at this point in time, was for them to show the lack of notice by showing when was the last time it was cleaned and inspected. They failed to show it. In fact, there were no records showing anything for a good 2 weeks before the happening of the accident. And so, again, we believe that these various...
Counsel, let me just,
Yes.
I just want to clarify. There were logs, but they weren't produced for this period of time?
There were logs that were produced up until August 31st, but not for the date of the accident. So for a good 12 days or so, there were none. And in fact, the gentleman who prepared those logs said that the lack of the logs being available to be produced is an indication to him that he probably didn't prepare it. Does that mean that he wasn't even inspecting or on the job site? Quite possible.
Okay. Thank
Again,
you so much.
thank you very, very much, Your Honors.
And last but not least, Arkin Kaplan Rice versus Howard Kaplan. You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court, Howard Kaplan from Kaplan Rice on behalf of Michelle Rice, my firm Kaplan Rice, and myself. I'd say appellants, but I think we're appellants and respondents because there are a number of appeals here. I'd like to start with the equal division rule, if I may. Section 40, subsection 1 of the New York Partnership Law requires that the equity partners share equally in the distribution of the firm's assets unless there is an agreement to the contrary.
Well, hadn't there been a practice within the firm that had payments going out to the partners in different percentages based on their equity in the firm?
No, Your
No?
Honor. That's, let me explain that because I think that's the crux of it, so thank you for asking that question.
Okay.
The testimony is very clear. At the end of the year, Kaplan, Arkin, Rice would sit down and decide how to distribute the cash in the account. It was never, ever based on percentages. It was never based on equity. That was never discussed. And in fact, the lower court recognized, obviously, there's no partnership agreement. I think everyone agrees on that. There was no agreement regarding ownership, and there was no agreement relating to the distribution of assets upon a dissolution of the firm. We think it's very clear, based on those admissions, which are undisputed, that Section 40, subsection 1, applies here. Now, I think,
Counsel,
yes.
sorry to interrupt you, but were there any disputes in the years that the allocations were made, say 2002 to the dissolution in 2012, about the allocations? Did people say, no, that's not correct? Any of the partners do that?
Going to the very last thing that you said, Your Honor, no, there was no dispute where someone said, no, that's not right, or that's not what I'm entitled to. I think the record is clear is that there were disputes, there were conversations, and that there would be a consensus of how to distribute the money, but it was never based on ownership percentages. That was never a discussion, Your Honor. Let me just turn quickly to what the lower court did. I think it's probably very clear. She took 10 years of K-1s, and she basically averaged the percentages on the K-1s. But even there, the testimony was undisputed and very clear that the percentages in the K-1s did not represent ownership percentages. And in fact, the firm accountant testified that that should have been blank, that that percentage was just added by a computer based on how much money people were getting. Your Honor, I'll wait for any questions on that because I was going to quickly go to Ms. Solbakken and try to use my time as efficiently as possible. We submit that Ms. Solbakken lacks standing and should have been dismissed from this case. Mr. Arkin testified twice that she was not an owner of the firm. Ms. Solbakken testified it was unlikely that she was an owner of the firm. And frankly, given these admissions at trial, Ms. Solbakken represented that she was only relying on judicial estoppel, partnership by estoppel.
Didn't you and Ms. Rice at some point during this long and tortuous litigation indicate that you considered Ms. Solbakken to be a partner?
The question there, Your Honor, was whether we called her a partner before dissolution. That was the question. The answer is yes. Mr. Arkin did. We did. She called herself a partner.
And yet, when the issue was joined in this litigation and about who the equity partners were, and we've had cases before the First Department on this very issue, Mr. Arkin said she's not an owner, and she said she's not an owner. So I don't understand how the plaintiffs can actually have standing, how Ms. Solbakken can have standing to be a part of accounting when she's saying that she's not a partner. And I would say, Your Honor, if that seems to go, although the lower court didn't analyze it this way, that seems to go to the indicia or criteria of partnership. It's very clear, I think, from a number of the cases that just calling someone a partner is not enough. I think there's the Desposito case, I guess, is one of the leading cases that we cite, where someone was called a partner, they were a partner in the tax returns and so forth, but the key aspect of it was whether they were responsible for the losses, whether they shared in the losses. That's what all the cases say. No question here, undisputed, Ms. Solbakken did not share in the losses. She had no responsibility for them. She didn't sign the lease. She wasn't responsible for that. So
Okay,
we
you'll have time on rebuttal.
Okay, thank you, Your Honor.
Michael Cook for Arkin and AKR. I'll be quick. What Mr. Kaplan is talking about is an appeal. The response to his appeal are two words: admitted and agreed. And I'm going to refer to the record. When I give you numbers, they're from the Kaplan and Rice record. First, on profits. The parties always agreed on profits. Mr. Kaplan admitted on pages 726 and 27, we decided, 951 and 52, we reached consensus. Ms. Rice agreed. 947, Mr. Kaplan, we talked about how much to distribute. What the court did is to base her finding of what they're entitled to is on the prior 10 years. And what she did, she didn't average it, as Mr. Kaplan said. She picked the best percentage for Mr. Kaplan, 20%, and roughly 16% for Ms. Rice. She cut Mr. Arkin down to 56. His best percentage was 62. They never objected to the financial statements, every one of which referred to who was a partner, what the capital account was, and what the profits were over the prior 12 years.
From 2001 to 2012.
That's right. And they just never did. They got financial statements, they admitted it. They got K-1s, they admitted it. They submitted them to the IRS. So that's just unbelievable. As far as Ms. Solbakken goes, they admitted she was a partner. Page 651, 725, Mr. Kaplan, I believe she was a partner. Ms. Rice, 651 and 55. Oh, I did believe she was my partner. And we had one class of partner. Now, Mr. Kaplan talked about no equity. Of course there was no equity. Mr. Kaplan, Mr. Arkin was the only one who contributed to the capital. The reason Mr. Kaplan and Ms. Rice had no equity, they had negative equity accounts because they were sharing in Mr. Arkin's depreciation at their request starting in 2004. They had negative capital accounts, so they had no equity. He's confusing, Mr. Kaplan's confusing, I believe, when he talked about ownership. Yes, there was no discussion of ownership. They agreed. They never discussed capital. They never discussed ownership. And Mr. Kaplan and Ms. Rice never contributed any capital. Undisputed. So between the tax filings, and by the way, what he didn't mention was Mr. Arkin's capital account. Again, as Justice Maisley, at the beginning of her opinion, you'll see at pages 102 and 103, she actually quotes from the transcript of March 9, 2018. Counsel for Kaplan and Rice, we are not disputing the capital account balance. Ms. Rice, page 70, says the same thing. He created this account. How did it get created? He provided the furniture, the equipment, the utility deposits, and the working capital. It didn't fall out of the sky.
Okay, why don't you address the issue of the post-dissolution rent and reimbursement of the letter?
This court has twice, starting in 2014, the seminal decision, AKR is liable for rent. 2019, I was here 2.5 years ago. Decision, we reject the argument that AKR is not liable for the rent. And what Justice Maisley did when the landlord sued, we settled with the landlord. She allowed the landlord to get paid out of AKR. She entered a judgment on April 2nd, 2019, and the landlord executed on the judgment. So what are we talking about? And the best summary of this whole mess.
Well, what we're talking about is that under the agreement, once a partner withdrew, they were no longer responsible for rent. That's what we're talking about.
Absolutely. You're 100%. Couldn't agree more.
So why should the AKR funds in total be used to relieve that obligation?
Because AKR is one separate entity. It is liable, no question. It was the primary tenant. The guarantors, Mr. Kaplan and Ms. Rice, were released. And when we use the passive voice, they were released. Who released them? Not this court, not any court, but the landlord released them. And if you look at the language of the lease, under this sublease, we release you. Under the sublease, we release you from any liability once you withdraw. So they're not liable. They're not liable. They've never been sued. The landlord never sued them.
Yes, but the money that was left behind, that was left to be distributed amongst those withdrawing partners, was used.
With a court approval, Justice Maisley entered a judgment. We went to court to ask her for that. And if you read Justice Owing's April 5, 2016 decision, he makes it real clear, the firm is liable. Merely because they're not liable on their guarantees does not mean that the firm is not liable. It's a separate entity. Why? The landlord would never release AKR, and it never did, and it never went after them. What the mistake was...
Yes, but you keep on ignoring the fact that part of their money was used to satisfy that judgment.
Your Honor, it wasn't their money. That's the point. When you look at the New York partnership law, what a partner has is a right to co-manage, to co-use the partnership property for partnership purposes. Can't use it for anything else for partnership purposes.
And can you and I agree that once they withdrew, the use of their money for the continuation of the rent was not for a partnership purpose because they were no longer a part of that partnership?
First, Your Honor, it was not their money. It was the firm's money. And
a part of that money belonged to them, still to be determined, but belonged to them.
Yes. What belongs to them is, at the end, if you look at Section 61 of the partnership law, the partnership continues until it's wound up and then terminated. 3 steps. Dissolution.
You're not suggesting that by giving life to the partnership law, we can ignore the agreement in the sublease provision that allows them to no longer be liable for.
I agree with you completely.
Great.
We're
All right.
alive. Thank you,
We're
Your
out
Honor.
of time.
Thank you.
Good afternoon, Your Honors. May it please the Court, Robert Angelillo for Respondent Lisa Solbakken only.
So, counsel, I just want to ask you, did Ms. Solbakken take the position that she wasn't a partner at the firm?
No, Your Honor. In fact,
So where did that come from?
there are some snippets of testimony cited in the briefing where there's questions about the nature of the partnership. But if you look at the briefing, particularly from respondents' briefing, there's an itemization of the way the partners acted and the way they treated each other, and it was almost uniformly the same between Kaplan and Rice and Arkin and Solbakken. There's some minimal differences that I would argue are negligible and certainly don't rise to the level of a denial of partnership. But what I wanted to address, and counsel I think addressed many of the particulars of the indicia in partnership and other items, but counsel for appellants referenced a term, partnership by estoppel. And that is certainly not the argument here. And I would direct your honors to pages 32 and 31, 32, excuse me, of respondent's main brief. And the argument is judicial estoppel. And if you look, it's detailed in the briefing, but the bottom line is Kaplan and Rice when they were served with the accounting demand from Arkin and Solbach and said, you would only serve that on people who are partners. And the court accepted that and said, yes, that's, and they achieved a benefit from that. They said everyone's a part. Everyone who was served with an accounting demand is a partner. They obtained a benefit from that. They served an accounting demand on Arkin and Solbach, and then now we're saying, but they are not partners for some unknown reason. The judicial estoppel argument is those who are served with the accounting demands are partners of the firm. They took that position. The court accepted it. They achieved a benefit from it. Now they're taking a contrary position only because it's Arkin and Solbach. And so clear principles of judicial estoppel say that they're barred from making that argument before this court now. If there's any other questions on that point, I'm happy to answer them. Otherwise, that's the limit of my involvement.
Thank you.
Okay, I have a lot to jam into 1 minute. I'm going to go as fast as I can. First of all,
You got two. Go ahead.
I'm going to get, Your Honor, to the question you asked, but very quickly. Ms. Solbakken said it was unlikely she was a partner, and just had it here. Let me give some cites to the record. First of all, in answer to the question of the annual distributions, R725 to 26, R479, R217 to 218, all very clear that that there is no agreement and the percentages had nothing to do with the agreement. In terms of Ms. Solbakken, I'm going to have to get that in a second. I'm sorry. Let me just turn very quickly. I think it's 5332 where she said that. It was deposition testimony. Let me just get quickly to this question about the rent. It is law of the case that Kaplan Rice were released from any liability under the sublease, as Your Honor said, and that their personal assets and partnership assets are released. I think we've beat that one to death, that issue. The clear implication of that ruling, of those rulings, there were two First Department rulings, is that if the partnership assets are used to pay post-dissolution rent, then Mr. Arkin has to return those funds. He's the one that's liable. He's the one that every judge that consider this has said is liable. And I just want to give you, there's a lot of discussion and a lot of confusion about all these transcripts and decisions. I just want to quote Justice Oing, who really, I think, hit it on the head in the middle of all this litigation. He said, Mr. Arkin and Ms. Solbakken are going to have to put the money back in right. It's about money at this point. So at the end of the day, I understand your concern about there is going to be nothing left, but at the end of the day, there are people that have to pay the money back. Justice Maisley said the same thing, and that's what she ruled both in the confirmation decision and the trial decision when she entered an order that he has to put it back. We think it's all law of the case and has been decided already by this panel. Any questions?
Thank you.
All right, thank you.
Mr. Arkin, you have two more. He has 2 more minutes. Mr. Arkin has 2 more minutes on Arkin's case.
And I refer the court to Justice Oing's April 5, 2016 decision. Again, to say that Kaplan and Rice are not liable does not mean that the firm is not liable. Justice Maisley, in October 2017, affirmed by this court in February of 2019, completely said it's not inconsistent with the firms having to pay rent to say that Kaplan and Rice don't have to pay. They're two separate entities, two separate contexts. And where nobody's taking their property, the only thing the partners have here is a partnership interest. You look at the partnership law, and the partnership interest is only determined after the firm is wound up, at termination. Okay? And nobody's touching it, nobody can, and nobody will. It's the firm assets being used for firm business, the firm rent. No court has ever said that Mr. Arkin has to return 1 cent. In fact, Justice Oing, on April 5th, 2016, when they tried to get the letter of credit, $900,000 back from him, said, I read the First Department's decision saying that's not required, I'm not doing it. When they sued Mr. Arkin again, along with a landlord for conspiracy. This court, Justice Maisley dismissed the suit as borderline frivolous, and this court affirmed completely. So Mr. Arkin was never ordered to turn back anything other than by Justice Maisley based on what the referee said. That's why we're appealing. Thank you.